supporting organization and sponsored by our platinum sponsors, including Dongguan Lawyers Association, 东莞市律师协会, LexisNexis Legal and Professional, Link Asset Management Limited, Willa Legal, as well as our gold sponsor, Hill Dickinson Hong Kong. I hope you are all refreshed after the lunch break. For those who were not with us this morning, my name is Joanna Tong, MC for today's conference. Before we start, I would like to remind you that the afternoon section will run from 2 p.m. to 5:25 p.m. and carries 3 CPD points. Please refer to the conference brochure for the program rundown, course outline, and profiles of our panelists today. For those who have also joined us this morning, please be reminded to sign in again in order to claim your CPD points for this section. There will be a short break at 4:10 p.m. Owing to the public health condition, eating or drinking is not allowed in the conference venue. You are also reminded to put on your mask at all times and maintain social distancing in the conference venue. The conference will be conducted in English and Mandarin and supported by simultaneous interpretation in the 2 languages. We have some devices for participants joining us here in person, which will be provided on a first-come, first-served basis. Users may select channel 1 for English and channel 2 for Mandarin. Please contact one of our staff members if necessary. For our Zoom participants, you may mute the original audio and select the audio channel from the control panel at the bottom to listen to the conference in your preferred language. Please turn your mobile phones and other sound-emitting devices to silent mode. You'll be given a name badge when you enter the conference venue. Please carry it with you at all times during the conference to allow our staff to identify you and to provide necessary assistance. You're welcome to raise questions at the Q&A sections arranged at the end of every panel discussion for the audience. For those of you who are joining via Zoom, please use Zoom's Q&A function. Panelists will address your questions if they see fit. It is our great honor to have the Secretary for Justice, Mr. Paul Lam, to be our keynote speaker this year. And I know I've taken up a lot of your time, so without further ado, ladies and gentlemen, please join me in welcoming Mr. Paul Lam. SJ, please.
President of the Law Society, CM, my good friend, distinguished guests, ladies and gentlemen, good afternoon. It gives me great pleasure to welcome you to Justice Place for the later half of this wonderful event organized by the In-House Lawyers Committee of the Law Society. Now, holding this annual conference in the Justice Place, which is the headquarters of the Department of Justice, is symbolic. Because as a matter of fact, the Department of Justice is the largest employer of in-house counsel in Hong Kong. Now, speaking for myself, when I prepared the speech, it occurred to me that I have just become an in-house lawyer for a little over than 2 months as the Secretary for Justice. Because most of you would know that I have been practicing as a barrister for almost 3 decades. Now, so I'm new to this job and I'm still getting used to this new role. So any tips and tricks from my friends who are in-house counsel will be most welcome. Now, the theme for this year is in-house lawyers being corporate connector. Now, I'm sure that you are well aware of your important role within your respective companies or organizations acting as such corporate connectors who serve to perhaps enhance corporate governance and compliance, avoid dispute, and handle dispute if they do arise. But what I wish to say is that what you must overlook is your important role in the context of the Hong Kong legal community, and indeed Hong Kong as a whole. Back in 2016, Mr. Justice Robert Tang, PJ, as he then was, remarked that in-house lawyers are a substantial force in the legal community in Hong Kong. This is undoubtedly an utmost important and accurate statement. Now, the way I construe this statement is that in-house lawyers, because of the peculiar nature of their jobs, can very often do what other private practitioners cannot or struggle very hard to do. Say, for example, they have the power to connect the employer's businesses to a particular jurisdiction. You may take part in deciding where a business should be headquartered, what should be the governing law of the contracts or the relevant contracts to which your employers are parties, and where and how any dispute arising out of these contracts should be resolved. And I still remember that in a very famous Hollywood movie, a certain masked hero had said, "With great power comes great responsibility." Now, not only do you have all these very potent and important powers, I would venture to suggest that you, as member of the Hong Kong legal community, also have a very serious responsibility. What I have in mind is the responsibility to connect business and matters under your sphere of influence with the jurisdiction that we are most familiar with, namely Hong Kong. So, for example, I would urge you to consider seriously to advise your employers to choose Hong Kong law as the governing law of the relevant contracts, and Hong Kong to be the jurisdiction where dispute should be resolved irrespective of how. In addition, when advising your employers, which outside law firms or lawyers, including solicitors and counsel, should be engaged, I would also encourage you to seriously consider Hong Kong local law firms and lawyers, as you will no doubt agree with me that many, in fact most Hong Kong lawyers are immensely talented and no less competent than their foreign counterparts. Hong Kong is already an international legal service and dispute resolution hub because of our common law system and our diverse pool of legal talents, to name a few our unique advantages. But a very unique and perhaps the most unique advantages enjoyed by Hong Kong is the substantial opportunities under or created because of the principle of one country, two systems. President Xi, in his recent speech made on the 1st of July, marking the 25th anniversary of the establishment of the Hong Kong Special Administrative Region, made it crystal clear that the principle of one country, two systems is a long-term policy that must be adhered to and will certainly go beyond 2047. This means that Hong Kong will remain as the only common law jurisdiction in our country, China, bring along with it fundamental features such as the rule of law and the independence of the judiciary. The National 14th Five-Year Plan, also mentioned by President Xi in his speech, explicitly support Hong Kong's development into a center for international legal and dispute resolution services in the Asia-Pacific region. This, coupled with other national development policies, such as the Greater Bay Area Initiative and the Belt and Road Initiative, make Hong Kong truly a place full of opportunities for the business and legal communities. Now, Hong Kong must seize the opportunities created by these national development plans proactively. Among other things, it needs to enhance the cooperation and collaboration between the two legal systems in the mainland and Hong Kong, respectively. Now, in this respect, Hong Kong has already entered into various legal assistance arrangements with the mainland on various matters. And I would like to take this opportunity to highlight a few which may be of particular relevance to your work as in-house lawyers. The first is a bundle of arrangements concerning arbitration, which provide a comprehensive regime for recognition and enforcement of arbitral awards between the two jurisdictions, and also allow parties to arbitral proceedings seated in Hong Kong to apply to a mainland court for interim measures. These arrangements are complemented by recent legislative amendments to the arbitration regime in Hong Kong, which permits agreements using outcome-related fee structure for arbitration, OFSA, I think that's the abbreviation, and also third-party funding for arbitration. And these measures were previously prohibited under, for example, the common law doctrines on maintenance and champerty. The second is a bundle of arrangement with the mainland concerning reciprocal enforcement and recognition of judgment, covering a wide range of commercial and civil matters, including intellectual property rights. Now, although the arrangement concerning a previous choice of court agreement is already in force for a number of years, the most recent bill to implement the latest arrangement concerning recognition and enforcement of civil and commercial matters is a very important development. It is currently at the bill committee stage in the Legislative Council. And in fact, I'm very pleased to say that we have already completed that part of the legislative procedure, and we are waiting for the resumption of the second reading of the bill. I hope and expect that the ordinance will be formally enacted very soon before the end of this year. So once enacted, the new arrangement, which will become part of our Hong Kong law, will offer substantial improvement to the previous regime. For example, it will include the removal of the requirement of an exclusive jurisdiction clause as a precondition for recognition and enforcement of the judgment. Lastly, I wish to mention the record of meeting concerning mutual recognition of and assistance to insolvency proceedings, which was signed in May 2021 with the mainland, which established a new mechanism which allows Hong Kong liquidators and administrators to apply to mainland courts in 3 areas, having regard to the fact that it's a pilot scheme. The 3 pilot areas are Shanghai, Xiamen, and Shenzhen, for the recognition of insolvency and debt restructuring proceedings in Hong Kong. Now, in practice, this means that assistance may be granted in relation to, for example, the taking over of debtor's property and investigation in the financial position of a debtor who is subject to insolvency or similar proceedings. Now, there's no question that this arrangement will provide better protection to safeguard the interests of the creditors. And I sincerely hope that this pilot scheme may extend to other cities in the mainland in the near future. I would also like to take this opportunity to highlight to you the initiative for wholly owned Hong Kong enterprises to be allowed to adopt Hong Kong law and choose arbitration to be seated in Hong Kong in their contracts. I think we have a very easy term, a simple term for that. It's 港資港法港仲裁, which are already in place in part of the Greater Bay Area. Now, this measure will create more options for companies and business enterprises seeking to grasp the opportunities in the Greater Bay Area. We are actively seeking to further liberalize the measure in this respect and hope to expand this measure to the whole of the Greater Bay Area, once again in the near future. Ladies and gentlemen, I'm confident that with the support of the Central People's Government, there will be more opportunities, benefits, and advantages to come for Hong Kong business and enterprises and indeed the legal community. My department, the Department of Justice, shall continue to strive for closer cooperation with the mainland authorities with the view to provide further benefits and advantages to businesses and the business community and the legal community in the Greater Bay Area and beyond. I would encourage you to capitalize on Hong Kong's unique advantage. Namely, while it's a part of China, it has a well-renowned common law system with a very long history of success. Now, with this remark, I hope you will enjoy the rest of today's conference and with more insightful discussion of common interest. Thank you very much.
Thank you, SJ, for your insightful sharing. Now it's time for our first section discussion of this afternoon. This section will be conducted in Mandarin. 以下环节将以普通话进行。随着中港两地经济联系越趋紧密，不少香港公司都积极参与跨境贸易和商业活动，连带对内地的法律流程、外判服务和外聘律师的需求增加。这一节专题讨论邀请内地私人职业律师和香港企业律师，就提供跨境法律服务互相分享经验，以协助两地法律专业人士更有效的合作。现在有请华润集团有限公司法律合规部副总经理董刚律师，通力律师事务所合伙人兼深圳分所管理合伙人黄海律师，北京市中伦上海律师事务所合伙人乔文俊律师，以及北京市安理律师事务所高级合伙人李征律师。本节将由领展资产管理有限公司总监、总法律顾问并购屈永谦律师主持，掌声欢迎几位。
好，谢谢刚才主持的介绍。那其实刚才介绍了几位讲者，这暂时大家只是看到我在现场。因为其实另外几位讲者都会在内地参加，通过 Zoom。那我先就开个头，然后我会交给几位的讲者去分享一下他们的一些见解。那首先跟大家打个招呼吧，就是各位领导，两地法律界的同仁，大家下午好。我们刚刚听完林司长的精彩发言，获益良多。刚才林司长其中一个谈到的话题，就是其实我们香港律师跟内地的法律界可以怎样加强我们互相往来，我们可以怎样做多一点的合作呢？那在我们目前内地跟香港的往来日益频繁，我们比较多跨境的业务要处理的环境下，其实我们双方的律师包括企业法务，我们之间的合作有什么最新的发展跟趋势呢？还有什么方面我们可以一起做得更好，做到优势互补，一起进步，做强呢？那今天我们就有幸请到几位行业内的大咖来跟我们做一些分享。那首先我是本个环节的主持人欧永谦 Alex， 我现职领展的并购总法律顾问。那我的职业生涯基本上离不开跟中国内地相关的业务，那所以今天呢，我会跟几位讲者，都是我们中国内地的律师，我们有企业法务，也有律所的律师，跟大家做一些分享。那今天的安排呢，我们会先请几位讲者分别发言，分享一下他们对今天主题的一些看法，然后呢，我们会有一些特定的话题。去做一些讨论，如果时间容许的话，我们也欢迎大家做一些提问。那可以通过 Zoom 的提问那个环节可以做。那我们现场的观众也欢迎你们做一些提问的。那我现在要不先请第一位讲者，华润集团的法律合规部副总经理董刚律师。跟大家讲一下，从一个涵盖内地跟香港业务的法务团队的角度，去先做一些分享。有请董总。
好的，谢谢欧总。那么，尊敬的林司长、各位领导， 两地法律界的各位同仁，大家好，很高兴今天能够有这样的一个机会和大家进行交流分享。那首先呢，请允许我代表华润集团全体法务工作者，向香港律师会秘书处的这次精心组织表示衷心的感谢。那华润集团呢，根植香港84载，我们的前身是1938年在香港创立的联合行，经过2次再造华润，现在已经发展成为一家大型的多元化国有资本投资公司。那我们现在呢，拥有在职员工大约是37.1万人，实体企业呢大约有2000多家，有8家在香港的上市公司。那么业务基本上我们涵盖了大消费、综合能源、城市建设运营、大健康、产业金融以及科技及新兴产业6大领域。我们未来的发展战略，坚持立足香港，面向内地，服务国家战略，深耕民生经济领域，以香港所需、华润所长为理念，在巩固现有业务的同时，着力加大向公用事业等民生基础产业的投资经营力度，加快向现代服务业领域的发展，进一步扩大咱们华润在香港的影响力，为香港长期保持繁荣稳定，增进社会民生福祉发挥更大的作用。那么刚才主持人也提到，像我们华润这样一个在港创业、坚持立足香港、面向内地的区域发展战略，而且目前已经逐步形成跨境经营、全国拓展这样一个经营格局的中资在港企业，是如何看待香港律师和内地律师合作共事这个议题呢？那么在这里，我想分享几点咱们华润在这方面的经验，和大家一起来共同探讨。一是我们打造了一支精通内地大陆法和香港普通法的法律精锐团队，形成了一个跨境法律事务协同的工作机制。那大家都知道，华润集团的总部和附属公司，我们现在总共有专职的法律人员有297人，其中国家司法部许可执业的公司律师有123人，那香港执业律师呢有13位同事。集团法律合规部在香港和深圳2地都有办公室，那我们部门里面有设置了很多专业职能组，各专业职能组呢在2地也都配备有专职的法律工作者。那我们既有在深圳办公室工作的香港执业律师，也有在香港办公室工作的内地公司律师。那各职能组之间，无论是在处理日常法律事务，还是在处理专项法律事务的时候，都是由深港2地的内地公司律师和香港执业律师在分工负责的基础上，充分进行沟通，沟通内地法律和香港法律，通力合作，相互支持，协调一致，协同完成。那另外，我们的法律团队当中，内地公司律师大部分都有在普通法适用地区学习和从事法律工作的经历，香港律师、香港执业律师也有很多工作实践和学习培训，不断提高对内地法律制度的理解和认识。举个例子来说啊，比如说我们部门负责这个资本证券和投资并购事务的同事，他们都有在香港知名律师事务所担任多年注册外地律师的经历，然后才到我们公司来转任公司律师的。另外，其实在我刚刚提到的13位香港执业律师当中，其中也有2位同事已经通过了2021年首次举办的粤港澳大湾区律师执业考试。那么这个已经完成了广东律师协会开展的集中培训和考核。那我们也知道，不久之后我们即将迎来第3次这个粤港澳大湾区律师执业考试，我们相信会有更多的同事同行参加这次考试。华润我们也非常愿意继续支持和帮助更多的香港律师同事同行们安心备考，助力他们通过大湾区的律考，缔结2地律师深厚的法律合作情谊，助力我们的法律工作再共同上一个新的台阶。第二是，我们其实非常重视外聘律师服务的采购管理，整合内地和香港2地优质的外部律师资源。那我们集团也制定了 相关的法律服务中介机构采购管理的有关制度。根据这个制度，我们建立了一个动态管理的外聘律师备选库。到目前为止，已经进入我们外聘律师备选库的有100多家律师事务所，遍布了内地各省、自治区、直辖市和香港特别行政区。那我们参照了大型律师事务所的业务分类模式，结合华润6大领域的经营管理实践，把已经入库的律师事务所和律师分为若干个大类，那又在这个大类里边分了若干个小类。这样一来，我们基本可以保证不熟悉内地法律服务市场的香港附属企业，也可以根据他们的实际业务需要，在这个律师库里面找到适合的律师事务所和律师。那在这里，我们也非常欢迎有更多爱国爱港、立场坚定、积极投身公益法律服务，在业界享有良好声誉的香港律师事务所和律师进入我们的外聘律师库，成为我们事业的合作伙伴。第三个可以跟大家分享的是，我们在日常工作当中组建了专门的公司秘书服务公司和知识产权服务公司，在为我们集团提供全方位高质量内部服务的同时，也致力于为外部客户提供连接两地的专业咨询服务。那作为一家驻港的央企，举办一个专门提供公司秘书服务的公司，其实也可以算是华润在专业服务方面的一个创新的举措。那我们在2017年的8月，着眼于提升公司治理能力，通过对标国际一流企业的模式，那华润集团呢注册成立了华润秘书服务有限公司，并且投入了运营。这家公司呢是由我们集团法律部直接管理的。在2018年9月的时候，咱们这个华润秘书服务公司从香港的公司注册处这边获颁 TCSP 牌照。那到目前为止，我们的华润秘书服务公司一共聘请了有超过大约20位持有专业资格的公司秘书，来处理华润系企业的境外公司秘书事务。那这里边也包括在香港的公司秘书事务。今年早些时候，我们把这个管理经验吧，也报给了国务院国资委。那经国务院国资委的同意，华润秘书服务公司在承担对内服务的这项职能的基础上，开始承接一些外部的工作业务，对外提供专业的公司秘书服务。那在这里，我们也是非常期待能够在今后的这个工作当中，有机会能够为更多的海外中资企业、香港本地企业提供一个连接中港两地的专业服务。那时间有限，我呢就暂且先分享这么多。那再次感谢香港律师会的同仁们，让我们携手共进，为两地企业蓬勃发展保驾护航，贡献咱们法律人的力量。最后，在这个疫情比较严重的期间，也是祝大家能够平安康泰。谢谢大家。
好，非常感谢董总的分享。那董总刚才的分享呢很有意思，是吧？也基本上我们接下来的讲者都是可以说是外部律师。那董总呢就从我们做企业法务的角度，还有是一家真的是不是只是在香港的，也不是只是在内地，而是两地的都有业务的一个大集团的角度，去探讨了分享了一下他们的团队是怎样组织的。中港不是中港，而是内地跟香港两地的律师，他们的协作模式是怎样？也探讨了一点，就是跟外部律师的刚才董总就是说一个 panel 的概念呢，就是他们怎样入库啊，怎样去管理他们外部律师，挺有意思。尤其是因为我本身是一名企业法务，那接下来呢，我们就要不我们今天是企业律师年会了，我刚才也用了一个 term 叫做企业法务，因为其实这个就是其中一个很好的例子。香港跟内地的制度跟一个文化方面的不一样，就是内地我们叫做法务，那很多时候呢我们讲律师就是外部律师， 那但是香港我们呢，就是我们都是律师我们做 in house 都好了，我们都会拿 practice 这样。那接下来呢，我们就听一听，就是外部律师，内地的外部律师是怎样看的呢？就是跟我们香港的律师，不单单是香港的法务，也包括香港律师，大家的合作方面会遇到一些什么问题呢？我们文化差异会不会导致我们的合作有一些磨合的问题？那他们有什么建议呢？那接下来呢，我们有请就是黄海律师，黄律师是通力律师事务所的深圳分所的管理合伙人。黄律师其实是会粤语的，是吧？但是为了方便其他内地的与会者，我们还是会主要用普通话加上英语的翻译。那我们现在先有请黄律师，谢谢。
谢谢欧律师。能听到吗？喂，能听到吗？
可以。
好的，谢谢欧律师。尊敬的林定国司长、陈泽民会长、各位领导、各位同学，大家下午好。我非常荣幸出席今天的会议。因为现场有政府部门的领导，有律师行业的前辈，有我的合作伙伴和客户。今天我其实是过来向大家学习的。我分享的主题是多方面了解内地律师。我先自我介绍，我是广东人，从小讲白话，看 TVB 和香港电影，对香港的文化是有共情的。大学期间，我作为学生会主席，也组织过两地的学术交流活动。我记得在2003年 CEPA 签署的前后，我们学校是组织过很多的这个两地学术交流的研讨会。我在那时候也对香港的法律文化和司法界的前辈有了初步的一些认识。工作后，我也经常与香港律师合作，也经常服务香港公司的客户，包括跨境投融资、并购、争议解决和结构金融等等。2013年，我作为合伙人也参与了筹备这个景天成与史蒂文森黄在前海的联营所，我本人也担任过联营所的负责人。那么在团队制律所的规则下，我是与香港联营所的同事有过深入的合作。2020年，我带领团队加盟公司制的通力律师事务所，并开设深圳办公室。正好通力香港与方维谷律师事务所它的联姻期满，并且也成功翻牌。那么我在公司制律所的框架下，也与香港办公室的同事一起共事。可以说，我过往的学习生活和工作的经历，能让我有更多的机会了解香港律师。事实上，我也经常给内地律师推荐香港律师，并提示双方在合作中应该注意的一些问题。今天的会议的主题是如何与内地律师合作和共事。我认为合作和共事的基础一定是了解。那么我从3个方面谈谈如何更好的了解内地律师，做个抛砖引玉。第一，了解内地律师的制度与文化。因为历史原因，两地法系不同，所以律师制度与文化也不同。比如在律师收费方面，香港总体是计时收费为原则，固定收费为例外。争议解决案件收费不与这个标的的大小挂钩，而且也不能风险代理。当然，香港最近也在推动这个仲裁案件的风险收费，我们也这个期待。而内地正好是相反的，这个大部分客户是无法接受这个计时收费，即使有计时收费，可能也会要一个封顶作为上限。那么民商事诉讼和仲裁的收费标准，主要是与这个标的挂钩，也可以进行风险代理。那么在角色分工方面，香港是有出庭律师和事务律师的区别的，而内地律师是没有区分。理论上的话是可以有这个万金油律师或者一条龙服务的律师的。当然，现在越来越多的内地律师会有自己的标签，有专业标签，也有行业标签，有的只做非诉，有的只做诉讼。这更多是律师的自我的一个选择，它不是一个强制的规定。 那么在律师管理方面的话，香港律师是受香港律师会的管理，对自己行为负责，在法律建书上是自己签字的，而内地律师是接受司法行政机关、律师行业协会的管理，还有事务所内部的管理。内地律师出具法律意见的时候，除了自己签字，事务所还要盖章。那么出了问题以后，事务所也是要承担责任的。所以在最近在推行的粤港澳大湾区职业律师制度，香港的律师通过考试以后，也还是要在国内被某家律所或者说有权接收的机构聘用才能进行执业。那么两地律师制度和文化其实还有很多的差异，其实大家以后的话可以进一步了解这是第一方面。第二方面的话，也建议大家了解内地的律师事务所的生态。如前面所述的话，内地律师是必须通过律所来开展职业的，所以对内地律所的了解是非常重要。经过30多年的发展，目前中国律师已经超过，就内地律师已经超过60万名，律所是超过3.7万家。那么这里面有全国性的律所，也有地方性的律所，有规模非常大的律所，也有比较精尖的律所，有综合性的律所，也有专注某个领域的律所，有一体化公司制管理的律所，也有联邦制或者邦联制的律所，甚至还有共享品牌挂靠的律所和这个个人所。那么不同律所的分配机制和人员结构不同，专业要求和客户层次不同，擅长的领域和地域优势也不同，这决定了这个合作的个案可能需要具体问题具体分析。在这里我刚才也非常感慨，刚才董总也介绍了华人对律师的管理，国内有100多家的律师，相信也能涵盖方方面面，回头也可以向董总请教。我建议大家的话，也是可以对内地的律所的生态做一些了解，届时也可以根据具体的业务需求和客户的要求，也结合大家对律所生态的了解，从专业、行业、城市等标签的维度进行选择合适的律师。我个人对内地律所的生态也是比较了解，就有兴趣的同仁的话，我们也是可以一起探讨。第三的话是建立有效的这个推荐渠道。前面2点很重要，但我们毕竟不是这个法律评价机构，也不可能花太多时间去研究内地的同行。那么建立有效的推荐渠道是非常重要的。在我看来，比较有效的这个推荐渠道主要是3个。第一个是靠谱的人，第二是优秀的律所，第三是权威的机构。靠谱的人既包括对内地律师比较了解的律师同行，也包括像董总这样经常使用内地律师的法务。毕竟律师的水平和人品还是需要通过合作才能印证的。优秀的律所是指在市场上已经建立了比较好声誉的律所，尤其是公司制一体化运作的律所，无论是他们自己的律师，还是他们推荐的其他律师，服务质量总体还是有保障的。第三的话，就权威的机构，这里面既包括主管的单位、行政这个行业协会等官方的机构，也包括知名的法律媒体。那他们在推荐的时候，一定程度上也还是有参考意义的。以上3点，了解内地律师制度与文化，了解内地律师事务所的生态，建立有效的推荐渠道，是我对了解内地律师的一些建议，班门弄斧。事实上，近年来香港律师与内地律师的合作和共事的机会越来越多，融合的话也越来越好。其实最显著的变化是，香港律师的普通话越来越好，内地律师的英文工作水平也在提高，大家在语言沟通上是没有障碍。在工作习惯上，内地律师也习惯用邮件沟通，香港律师也越来越熟练用微信。那么在业务类型上的话，就无论资本市场还是投融资并购、知识产权、公司合规、仲裁、民商事诉讼、婚姻家事等等，内地律所与香港律所的合作是越来越紧密的。那在工作场所上，香港律所中或者香港的公司中， 有这个内地背景的注册外地律师是越来越多，然后常年 base 在这个香港，常年 base 在内地的香港律师也是越来越多的。我相信，随着内地与香港在经济活动中的进一步融合，也包括粤港澳大湾区的发展，两地律师的共事和合作的机会是越来越多的。最后我也呼吁两地政府、主管部门、行业协会可以创造更多的机会和平台，让两地的律师能够更好的沟通和合作。也呼吁香港律师同仁多点到内地去，主动与内地律师接触，通力合作，这样是增进了解的最好的方式。谢谢大家。
好，谢谢黄律师。那黄律师从内地的外部律师的角度跟我们分享了一下，就是这个他们的行业生态啊，我们的沟通方式的一些改变啊，非常有趣，谢谢。那接下来，要不我们就请下一位讲者了，我们有请乔文俊律师。那乔律师是中伦律师事务所的上海所的创始合伙人，会跟大家分享一下法律服务的数字化转型啊，还有外部律师可以怎样去支持企业法务的工作等等。那我把时间交给乔律师了，有请。
好，谢谢 Alex。非常感谢我们香港律师会、香港的我们的这个法务顾问的这个委员会，同时呢，要感谢我们华人集团，也感谢我们领展来支持这个项目，跟有机会让我们呢能够内地律师跟我们香港的同行和香港的公司的法务呢能够一起交流。今天呢。我此前跟我们的主持人呢也沟通过，我想我们除了交流内地的律师跟香港的同事在专业工作的这个方面的这个一些内容之外呢，我想谈一谈我们内地的律师怎么样能够跟上我们香港和国际的公司的法律这个公司发展的步伐，能够使得我们的服务呢与时俱进。因为我此前呢也是中伦律师事务所的管委会的成员，就像刚才主持人介绍的，我是中伦上海的创始人。其实我跟香港的同行和香港的公司开展业务合作那是比较早了，从1994年开始，当时有一波我们叫房地产的发展，蛮多的香港的公司，包括新鸿基，包括和黄。包括恒隆在国内的发展，那么我们作为国内的律师呢，有机会能够跟我们香港的公司的律师和香港的同行，包括麦坚石，包括Johnson Stockmaster， 还有和黄乾亨等大型的律师事务所一起合作。那么在整个的发展的过程当中呢，应该说我们内地的律师从香港同行和香港公司法务这边呢学到了很多。并且呢，在这个过程当中呢，开拓了我们的眼界。那么在过去的近30年的这个发展过程当中呢，我们香港的公司和法务呢，也都在与时俱进，而同时我们国内的同行也一样在随着整个中国经济的全球化和国际化呢，也在往前发展。那么我在1994年的时候呢，是在上海本地的一个律师事务所，到了2001年呢，加入到中伦，做中伦的上海的这个筹建人。那么一晃也是有20多年过去了，在过去的20多年时间里边，我呢也是作为整个中伦的执行委员会的主任，参与了整个事务所近20年的管理，在这个过程当中，希望内地的律师事务所的能够提升，管理能够提升，在我们的理念上能够提升，在过程当中，其实很多是得益于我们香港的同行，也得益于我们香港的公司的客户包括一些在香港有地区总部的一些公司的我们的这个叫法务总的给我们的建议。整个的这个过程其实是沪港两地 或者说是我们的这个大陆和香港两岸的这个合作和交流非常多。那应该说国内的这些同行，我们现在除了规模是越来越大，因为这方面呢，是因为我们要覆盖的地域和服务的这个企业数要相比香港来说要大很多，所以也是因此呢催生了我们的这个发展，包括我们现在的一些所谓的这个红圈所红圈所现在都是几千个人的规模了。现在国内呢事务所还有甚至是达到上万个人的这个数量级。那除了这些规模之外呢，我们的运营管理，刚才我们的黄律师同行同理所的也介绍了，我们有各种各样的模式，有各种各样的这个体制，这些呢，我觉得也是说明中国大陆的整个市场环境也是对我们整个法律服务业的这个发展也是非常有利。总体上来讲呢，我们是有各种各样的这个渠道，叫八仙过海，各显神通，发挥各自的这个专长，去摸索有利于我们法律服务的这个路径，去更好的服务我们的公司客户。那么现在我们面对的时代呢，是一个不仅仅是一个信息化的时代，更是一个数字化的时代。我们中央政府呢，也是从几年前就开始要引导和鼓励我们各行各业搞数字化的转型。从去年年底开始更是着力的鼓励我们各行各业，其中包括我们法律服务行业要做数字化的转型。尤其是在我们现在的疫情期间数字化的转型这个重要性，对于我们律师事务所外部的律师事务所更好的服务于我们的公司客户是更有必要性，也是体现了它的这个价值。因为我们现在大陆的一些法院现在开庭也是做线上的开庭，然后我们仲裁的案件在过去的几个月里边，因为疫情的影响，所以现在也在线来进行仲裁。那过程当中呢，我们很多的客户呢，还是时不时的需要我们提供专业的法律支持。那怎么弄呢？那我们呢，也是一方面是通过互联网给他们在线的电话呀，在线的一些合同的这个审阅呀，包括一些合规的核查呀。那除此之外呢，我们所谓数字化里边呢，还有包括运用我们的大数据，运用我们的人工智能的一些技术，甚至一些云计算的一些技术，是服务于我们的客户。所以我们现在在国内的律所呢，也在探索，可能这方面呢，相对来讲，相对于我们香港的这个同行来说，更有这个紧迫性和需要，因为我们客户都转成了数字化了，我们所以在做法律尽调的过程当中，在帮助客户进行合同的审阅审查，包括KYC 的审查，甚至是一些招投标的项目的这个法律服务过程当中，都在运用大数据，都在运用一些我们叫在科技上来讲最通俗的一些人工智能的一些手段，甚至是一些云计算的一些方式。那么我们呢，律师事务所呢，作为国内的一个特殊的一个机构它不是一个公司，所以我们呢还在突破我们现有的体制的局限，我们去跟外部的一些科技公司进行合作，开发一些能够服务于我们自身的事务所管理的也服务于我们客户的一些软件、一些科技的工具。这方面呢，我想我们通过过去的1年差不多1年到1年半的时间的这个尝试应该说是还是很受益的。所以我想借我们今天的香港律师会今天这个论坛跟大家一起分享，以后呢也有机会呢跟大家一块探讨。在这方面呢，我们希望把我们的服务专业的服务和科技要能够更好的结合，使得我们的这个服务呢，除了法律上更专业之外，还要有行业的更多的经验， 更要有与时俱进的科技化的服务的能力。所以今后可能我们面对我们的香港的这个客户要提供服务的时候，还不仅仅是一个律师站在面前，还要有一个可能技术的IT 的这个方面的这个人员能够配合服务。因为我们的很多的客户在大陆发展，也是全国各地比较分散甚至是叫境内和境外要联动有一些客户甚至是叫全球的布局。那么这个过程当中呢，我们需要互联网的技术，需要5G，更需要我们运用云计算和大数据的整合。因为现在我举个例子我们在过去的3个月里边接受一个客户，他要去做并购，并购的是国内的近300个商业广场。那近300个商业广场遍布在全国196个城市，要同时做法律尽调。那同时法律尽调的过程当中呢，还要去做实地的访谈，并且呢要把它历年的商业的合同、租赁合同和一些施工的过去的合同都要进行核查。如果是需要派人的话，最起码要派200个职业律师才能够同步在2个月之内做完。所以我们在尽调的这个环节上，运用科技的一些软件，显得就尤为重要和必要。那么在过程当中呢，还要跟客户已有的一些数据，比如说一些商业的这个租赁合同的数据，他们一些物业服务的这些数据一些客户的数据，都要能够直接对接。直接对接以后呢，也方便我们很快的借助于软件来进行核查，进行梳理。所以在这些方面的话呢，我想我们对于专业的律师来讲在新的时代也面临新的考验既要专业要有标签，同时呢要有行业的知识和经验的标签，更要有一些科技的必要的这个手段这个工具。所以我们对于数字化转型和人工智能的理解呢可能要比一般的我们的社会的公民要更深一个层次，不是简单的是说去打造一个机器人，一个机器律师坐在面前替代我们人工，而是可能我们现在要用的这个大数据的这个一个平台，一个辅助的软件它是一个辅助性的，是帮我们更好的去省掉一些不必要的繁琐的人力，同时呢让我们更专注在我们的法律专业的思考方面去寻求解决方案。那这些方面的话呢我想我们香港的同行在服务，如果是在境内外有跨地域的，甚至是项目成百上千的一些法律管理的工作的，包括日常的我们叫常法的这个管理包括法律服务过程当中一些合规的审查包括一些合同的管理和审查方面，可能这些方面的需求就尤为必要。那么在境内的话呢，我们现在也知道我们的同行包括盈科包括我们的大成律师事务所，这些规模体量在前列的那些事务所也花费了蛮多的这个资金投入重金在打造自己的数字化的平台，一方面提升我们内部的管理，同时呢提升我们对客户服务的能力。所以我希望我们呢在通过今天这样一个论坛，不仅跟我们香港的同行有一个交流，也跟我们的境内的同行有一个分享，大家呢集思广益，能够把我们的服务的这个质量和水准呢能够提上一个新的档次。我们要立志要做的事情，不是仅仅是在中国地区或者大中华地区我们能够成为一个 leading 的一个 law firm， 一个legal service advisor， 我们更要在全球的范围能够有一个在另辟蹊径、弯道超车，甚至是做出我们中国特色的法律服务业的一个前景。 我想我这边的分享呢，是主要是抛砖引玉，因为我曾经是一个事务所的管理者，同时呢也做过上海律师协会的副会长，我还曾经带队到香港律师会跟我们香港律师会的同仁进行过交流，当时的会长是叫侯君尧所以我想我们通过这样一个和这港和这个大陆的这边的这个桥梁能够有更多的渠道和更多的沟通，使得我们的这个服务呢更贴近我们的客户，更贴近时代的脉搏，好吧？谢谢。
好，谢谢乔律师的分享。那其实讲到科技数字化的东西的话，其实我们有很多东西可以跟我们在内地的同僚学习的。因为刚才乔律师讲到，就是因为数据大，项目也多。那我们比方说刚才提到比方说做尽调的时候，那用人是不是足够呢？那很多时候我们开始要应用 AI 了。那这个因为我是做并购的，就接触的比较多。另外一块就是我们也发现除了我们工作方面以外，其实内地的法律制度也是在贴近这个时代的发展。比方说到这个数据的问题科技了，那我们说到，比方说我举一个例子，我处理过一个项目，就是电子签。在香港的话呢，其实没有什么法律去支持电子签，就是 digital signing 这个法律的基础。怎样去避免争议的发生？但是在大陆的话呢，其实有一套非常完整的就是基于电子签名法还有其他法律相关的配套，
没错，
让大家是可以有一个很好的法律基础去尤其是大陆这么大，那我们有一个，比方说 Party A 是在上海 ，Party B 在重庆的，那没理由我们要走在一起，来签个约。或者是我们 A 签完再寄给 B， 再寄来寄去这样。那基本上现在内地怎样呢？就用电子签，有很好的系统。举一些例子，连接去公安系统，确定签名人的一个identity。那公章怎样可以确保是真实的？那大家这个经济发展呢就可以很顺的去走。那这些都是一些我们香港律师呢可以多向内地同僚学习的地方。那接下来呢，我们就有请李正律师。李律师是安理律师事务所的高级合伙人，会跟我们分享一下跨境诉讼方面的一些见解。那现在有请李律师，谢谢。
感谢主持人，尊敬的林会长尊敬的林司长、陈会长，尊敬的现场的各位嘉宾以及各位同仁，大家下午好。我今天呢，能够参加这次会议呢，首先应该非常感谢华润集团。刚才董总也谈到了，华润对外有合作100家律师事务所，那么安理呢，其实也是其中的一家律师事务所，也是由华润集团推荐我们能够参加本次的活动。为了分享今天的题目呢，我做了一个简短的一个PPT。抱歉，这个我现在不知道能不能分享，不知道大家能不能看得到。我的 PPT 的分享能够看得到吗？
暂时没看到。
稍等啊。抱歉啊。
律师，要不这样，我们工作人员正在看这个问题，要不你也可以先做一些分享，因为我们时间也有一点紧张。
好的，好的，好的，
谢谢你啊。
好的，好的。那因为 PPT 打不开，我就把相关的内容。今天呢，因为刚才黄律师其实也谈到了，香港是一个普通法的国家。我今天分享的题目呢，多少有一点班门弄斧，但是希望通过这样的一个班门弄斧，能实现一个抛砖引玉的一个结果。 我今天分享的题目呢，主要是从判例法，从这个最高人民法院以及广东法院所公布的一些典型判例来去谈我对跨境争议解决的一些思考。那么我今天分享的内容呢，主要3个部分。第一部分呢是关于中国对外开放的2个重大的举措。各位也都知道，那么中央提出了建设粤港澳大湾区。那么从相关的数据显示，粤港澳大湾区是1个国家2种制度，以及3个关税区和3种货币。粤港澳大湾区目前无疑是中国开放现在程度最高、经济活力最强的区域之一。那么从几个数据的情况能够看出这个区域发展的活力。大湾区的经济总量从2018年的10万亿元已经达到了2012年的12.6万亿元。2022年的6月22号，最高人民法院就建设大湾区3年规划，那么出具了一个相关的报告。这个报告呢，从5个方面的内容做了相关的总结，包括完善相关的制度的机制，深化相应的合作交流，畅通规则的衔接，优化营商的环境，以及完善跨域的服务等方面，介绍了人民法院服务和保障粤港澳大湾区的主要建设情况。在这份报告当中，明确提到了近3年大陆的内地，也就是最高法和香港已经签署了在5项相关的协议安排基础之上，那么又分别签署了3项的相关的协助安排和1项司法协助的文件，和澳门也签署了2项司法协助的文件。在相关的数据统计，2019年到2021年3年的期间内，大湾区内地的法院审结的案件的数量涉港澳台总共有5.36万件，包括一审审结的相应的破产案件有1.31万件，依法出清僵尸企业，助力危困的企业恢复生机。上述谈到的数据确切地表明，中国的这个区际民商事司法协助的体系已经进入了一个快车道发展的这个轨道。那么第2个中国对外经济发展的第2个重要的举措就是“一带一路”的建设。“一带一路”从2013年开始实施到2021年，相关的数据统计，“一带一路”国家累计的贸易总额已经达到了11万亿元，双向的投资超过了2300亿元，工程承包总额也超过了7300亿元，为当地总共创造了34.6万个就业岗位。那么相关协议的签署情况，“一带一路”沿线总共签署了7个自贸协定和55个双边投资的协定，包括中国率先批准区域全面经济伙伴关系协定。那么从这2个重大的举措的情况来看，我们认为中国的涉外司法改革已经开启了相应的序幕。那么对于中国的司法的公信力提升具有重要的一个意义，尤其是对于这个涉外审判需要有一个强有力的一个公开、公正、高效、廉洁、可预期的一个司法审判体系提出了比较高的要求和相应的标准。那么基于刚才我谈到的2个重要的举措，那我们希望能够从最高人民法院以及广东高院所公布的相关的案例当中来去看中国涉外审判的相关的现状以及对未来的期望。我选取的案例的样本基本上是最高人民法院所公布的第1批、第2批和第3批为“一带一路”建设提供司法服务和保障的典型的案例，以及最高人民法院关于涉外审判的第21批的公报性指导案例，那么还包括广东高院所公布的第1批、第2批、第3批和第4批的粤港澳大湾区的跨境纠纷的典型案例，总共选取了121个案例，其中合计其实是124个案例，当然其中有2个重复案例，和1个非涉外的案例，那么实际分析的样本大概有121个案例。121个案例，我们选取了9个不同的维度来做相应的分析。那么基于PPT 没法展示，所以我就口头 向各位能够介绍一下相关的分析情况。第一个呢，从案件的类型上来分析的话，那我们总结的情况发现，所公布的这121个案例，那么涵盖了关于合同类的纠纷，包括公司类的纠纷，包括侵权类的纠纷，还包括对外司法协助、认可和执行相应的裁决和判决。那么也包括其他类型的相关的纠纷，包括还有4个行政诉讼类型案件的这个典型案例。从这些案例公布的情况来看，排名前4位的是我刚才所提到的这4种类型的案件，大概占到整个121案件当中的82%左右，那就说明这4类案件能够有一定的普遍代表性。其中关于合同类的纠纷，从目前的情况来看，排名前3名的是买卖合同的纠纷、运输合同的纠纷，以及借款合同的纠纷。那么这在一定程度上体现了涉外整个经济活动的高发的一些领域，尤其是争议高发的一些相关的领域，跟经济活动的外部特征是有一定的关联度。这是从合同的类型上来去做的相应的区分。那么第2个维度呢，我们从案件的管辖，众所周知，中国的司法机关对于案件的这个涉外案件的管辖，基本上是分为4个维度，一个是特殊地域的管辖，一个是协议的管辖，一个是漠视的管辖，还有专属的管辖。那么从我们调研的121个案例的样本当中来看，这个对于案件的管辖并没有太多的相关的争议，但从案件事实介绍的相关陈述情况来看，那么选择这个相应的管辖法院，绝大多数是依据特殊这个连接点也就是说密系联系点来作为相应的管辖法院的一个主要的一个依据。但在关于管辖方面，那么需要能够看到的是，作为这个特殊管辖在实践操作当中，那么存在好多的争议。目前从中国大陆法院所规定的相关的司法解释来看，对于管辖的密切联系点大概规定了6个方面，但这6个方面是作为协议管辖的相应的有效的一些依据。实践情况当中，那么也存在着双方在选择管辖法院，那么与本案争议这个联系点不存在的相关情况，而被法院认定没有管辖权的情况，也是客观存在的。这个在最高法院的相关的案例当中，也有相关的体现。那么第3个方面呢，就是关于涉外的因素。关于涉外的因素呢，大概从主体、客体和内容方面，我们大概做了一些相应的分类。121个案件当中，其中关于这个主体方面，有115个案件是属于主体方面的涉外。那么客体涉外只有1件案件是客体涉外，其中内容涉外的因素大概是有5件。这个在一定程度上反映了整体涉外这个案件因素的相关的一些情况。第4个维度呢是关于跨境平行诉讼。那么在跨境平行诉讼过程当中，我们目前看到121个案件，其实只有1个案件涉及到这个跨境平行诉讼，但并不完全符合跨境平行诉讼特点，因为这个案件是当事人选择在境外法院诉讼之后，那么由于送达的问题迟迟解决不了，那么当事人从而选择在境外诉讼撤销之后，再回到内地的法院进行相应的诉讼。那么在这一方面，是基于在境内的法院诉讼过程当中，案件的诉讼的时效存在的问题，那么引发了上一个这个审理过程的一些查明，所以这个案件我们把它归结为是跨境平行诉讼的一个延伸的案件。第5个方面呢，就是关于准据法的适用。从121个典型案件的情况来看，适用大陆准据法来裁决的大概有97个案件，而适用域外法裁决的案件只有8件。那么5件呢是区分不同的法律关系，这个适用大陆法和域外法来进行同时裁决，同时适用国际公约和条约来进行裁判的案件大概有11件。 这是关于准据法的适用。那么从域外法的查明情况来看，在整个涉外案件的审理的过程当中，域外法的查明是一件非常重要的事情，不仅关系到案件公平审判的要领，同时对于提升中国的国际公信力，尤其是司法判决的公信力，也是中国参与国际法治构建的一个重要的渠道。在2018年最高院成立商事这个审判厅之后，那么关于域外法的查明，从民事法的司法解释放宽到相应的这个查明的渠道，那么增加了到7种查明的途径，那么包括当事人提供、法律专家提供，以及通过这个法律机构，包括商事厅有专家委员会等等相关的渠道来进行查明。那么关于这个查明的主体，中国的法院也规定了是由这个2种的渠道，是以法院查明为主，当事人查明为辅。那么在当事人查明的适用过程当中，是在涉及到双方协议适用这个域外法律，那么由当事人来承担相应的举证责任和义务。这是关于域外的查明。在我们公布的121个案件当中，涉及到这个公共利益审查，我们看到有大概3起案件涉及到公共利益审查，其中2起是以这个进口国外的废弃物有关，那么受到中国法律的这个合法性和效力的审查，1起案件是以出借医疗经营许可证相关，那么内地的法院采取公共利益审查的方式，那么否决了相关合同的效力。同时呢，我们分析的维度也涵盖了关于示范的相关的内容。那么从示范相关内容上来看，我们大概归纳总结一下，涉及到这个市场经济秩序的案件大概是有40件，涉及到公司内部治理的大概有14件，涉及到法律适用的大概有10件，营商环境的有20件。那么这是排名靠前的这个示范的这个相关的内容。同时包括一些新型的案件和平等保护不同市场主体，应该说涵盖的内容比较广泛。这是121个案件整体调研的一些相关的一些情况。那么从典型示范案件的这个事例的情况来看，那么示范的意义价值，我们认为在每个典型的案件当中都有所体现。基于时间的关系呢，我就不再一一的去这个分享大概的案件的情况。那么这些案件分享的意义，或能够通过这些案件的分享，坚持法治的人领，包括平等保护中外当事人双方的利益。那在案件当中，最高人民法院也是选取了2个不同类型典型的案件，一个是保护涉外主体的利益，一个是保护内资企业的利益。那么在保护的标准上都是持以同等的一个标准来进行保护，2个案件也非常有典型代表性。那么包括这些示范的案例，对于鼓励坚持协同创新，健全国际商事的多元调解的机制，那么在案件调解当中采取一站式综合多元化的调解的方式，快速高效解决当事人双方之间的分歧。那么在新兴产业方面，那么加强新兴产业的引导，来促进新兴产业的健康发展，尤其是在海南自贸区以及相关的经济合作区当中涉及到消费合同案件，那么包括进口平行汽车，这个购买这个游艇此类的案件当中，那么对于此类新型案件的一些交易规则，通过公报案例树定了一些交易的秩序和方式。这是第3点。第4点呢，在121个案件当中，有10多个案件是涉及到司法协助和这个相互合作协助。在这方面，那么最高院的公报案例和广东高院的典型案例也体现了这样的一些合作的一些特点，包括对于典型案例，那么加强示范作用，引导当事人增强商业的预期，都起到了非常好的效果和作用。这是关于121个公报案例的相关的情况。那么通过这些案例分享的一些情况，我们大概总结出目前中国涉外审判现状的几个特点。第一个呢，就是已经通过涉外这个大量的案件的审判，积累了丰富的涉外审判的案件经验。那么从公布的典型案件的情况来看，所有的诉讼案件，尤其是最高院公布的一些案例， 呈现出诉讼的一些多样化、多元性，包括有前瞻性和复杂性的特点。为每一个案件树立了一些裁判的一些标杆，那么增强了中国法治的一些公信力。第二个呢是外国法查明的体系已经初具的规模。那么在我们所有收集的121个样本当中，没有一起是因为无法查明相应的外国准据法而导致适用中国内地法的相关情况，说明中国涉外审判的域外法查明的能力已经得到了很大的提升。那么尤其是各地法院分别建立了域外法查明的合作机构和相应的专家库。深圳前海法院这个就域外法的查明提出了3条的标准，叫认得全、查得明、用得准的原则，包括最高人民法院商事审判厅建立了相应的这个专家委员会的查明、专业机构的查明以及法律查明资源库等多种方式来去查明域外法。第3个方面呢，在整个司法审判当中注重提高判决的权威性和司法公信力。那么在我们调研的案件当中，很多案件是由涉港澳的居民选择深圳内地的前海法院来作为这个管辖地法院，那么也体现了内地法院在涉港澳居民当中的一定的公信力。第4个方面呢，在裁判案件当中这个援引国际条约和国际惯例的比重得到了一定的程度上的体现，包括蒙特利尔公约、联合国国际货物买卖公约，包括跟单信用证统一惯例这些国际惯例和国际条约，也展现了中国司法的一些自信。这是我们对于涉外案件总结的一些现状。那么对未来的展望呢？我想借用习近平总书记的这个主席的一句话，那么在庆祝香港回归25周年当中提到，中央政府完全支持香港长期保持独特地位和优势，巩固国际金融中心、航运、贸易中心地位，维护自由开放的营商环境，保持普通法制度，拓展畅通便捷的国际联系。那么这也是我们对未来涉外仲裁和诉讼的一些期许和期望。在这个方面有3点。第一点呢，在国家的政策层面上，我们认为涉外审判是这个有极大的国家政策的支持。那么内地和香港分别已经签署了9份的司法协定，在相互认可和执行裁决、保全以及这个协助破产程序方面提供了重大的一些便利。国家“十四五”也明确提出关于建设亚太国际法律中心。那么根据中央的文件司法部刚才黄律师和几位律师同仁也分享了这个包括我们华润也有3位律师被聘为这个粤港澳大湾区的律师为这个涉外的律师在境内提供相应的这个服务，那么创造了非常便利的条件。第2个方面呢，就是特区的政府是高度的重视。那么包括出台了陆续的一些相关的政策强化法律和科技。刚才乔律师也特别分享了关于科技方面的一些话题。那么在这方面，对于加强两地之间的交流和合作，和通过以香港为媒介加强对国际组织的交流合作，那么起到了非常好的一些基础和示范效果。第3个方面中央政府也提供了一个非常好的平台，也就是前海中央的法律服务平台。在这个平台的基础之上，有了系统化的一些实施方案，而且中央也有明确的相关的一些措施和举措。那么从我们相关的数据的情况来看，从2015年到2019年，共有54个案件在深圳前海的法院选择适用这个香港法，那么成功调解的案件达到了12件，判决24件。所以这个比例方面，我们认为也是非常可以期许的。截止到这个2019年的数据呢，我们看到整个内地法院成功调解的案件也达到了3796件，所以这些数字能够显示出整个涉外审判在深圳前海这个平台上的一些蓬勃发展的这个现象。这是我今天呢跟各位嘉宾分享的话题感谢主持人，谢谢大家。
好，谢谢李律师，我们学习了。那再次感谢各位的精彩分享，非常有用。那由于时间关系其实我们是收到一些问题了，那我就综合一下吧。我就问一个问题，来让可能2位律师吧跟我们分享一下，因为我们说到两地律师合作， 其实我们讲了1个多小时了，其实不是什么新鲜事，因为大家想一下，改革开放以来呢，都几十年了。比方说刚才乔律师提到，他94年开始就跟香港律师合作，就不是什么新的话题。那我们谈个比较新的话题吧，这新冠疫情。那诸位讲者，你们对于就是最近2、3年的疫情，你们觉得有没有怎样影响到我们两地律师的协作模式？那你们在职业方面又有什么模式上的一些转变，可以让我们两地律师可以继续很有效率的合作呢？那可以跟大家分享一下吗？那这个话题我知道之前黄律师跟我聊过一点，要不黄律师先请，然后我们再请另外一位律师再分享一下。
好，谢谢欧律师。是这样，就是因为这2年这个疫情到来以后的话，最直接的就是，其实两地律师，我讲的是主要是外聘律师了，这个业务是减少了，因为这个合作的前提是先有业务，对吧？因为疫情对两地的经济影响还是非常大的，所以直接导致了传统的像金融啊、资本市场啊、跨境交易这类的案件还是减少的。就是说有类案件是增加了，就是说跨境的这个争议解决和破产重整，或者一些另类资产的投资机会，这些是增加的。那么这里面的话，就是说不同的客户他的付费能力和预算可能也有些区别，所以总体来讲的话，这2年我了解到的就是业务的总量应该是低于这个疫情前的，这是业务量。第二的话就是说，因为这个疫情之后，就是两地往来不方便。最早的时候是两边都要隔离14天，那么我们深圳、香港只有1河之隔，其实距离是28天。到后来的话，就是14+7啊，或者说14天的回港易等等，这个时间还是会带来很多的不便。但是我们在这个危机当中的话，毕竟危机有危有机嘛，就是也是看到有些新的机会。刚才提到的就是合作模式方面，因为咱们今天主要的嘉宾都是公司律师为主，其实我认为作为香港这边公司的律师，在与内地大陆律师合作方面的话，其实对可能疫情方面不会说给你们带来什么不便，反而疫情之后的话，就是大家都习惯了就用视频会议或电话会议，其实效率也许可能比以前更高了。就是以前可能能够现场开会的时候，一天可能只能开2个会，但是可以视频或无线会议的时候，一天可能可以开好几个会了。这个从效率上来讲，可能反而针对可能香港的公司律师来讲，也许可能是一个更好的一个提升的形式。第二的话就是说在这个业务领域方面的话，就是刚才乔律师也提到了，就是说现在国内的数字化的发展，就是在律师之间的合作的话，就是各类的程序、各类的软件也是很好的提高了效率。尤其在疫情期间，大家见不了面的时候，这一块的这个作用也发挥了比较好的一些这个基础。第三的话就是刚才我提到就是可能传统的非诉类的业务这2年可能因为交易机会的减少，可能会相对偏少一些，但是确实争议类的案件是更多的。刚才吕律师也做了非常好的一个介绍，所以我们在这个未来，也许在很长一段时间，可能我们过往10几年当中，有一些这个海外的中国的企业在海外走出去的时候，或者说搭一些红筹架构的时候的一些经济实体，可能会随着经济的下行或者洗牌，可能会出现新的纠纷或者重组的时候，这个时候就确实非常需要国内和香港乃至境外的其他律师一起通盘合作一起来把这个事情给解决。所以我觉得未来的话，就是说双方合作的方式和业务领域可能会发生一些变化，那总体肯定是越来越好的。最后的话就是说我还是相信，就是疫情肯定会过去的，而且因为疫情而带来的政策各方面的影响肯定也会减少，所以我还是看好，就是未来就是说我们的经济和生活肯定是恢复到这个之前的一个正常的一个水平。最后反正希望大家相信，就是说长期看好中国 Long China。谢谢。
好，谢谢黄律师。其实这样，我秘书处已经不断提示我们已经超时很多了。那这样吧，我们就再一次非常感谢4位大咖跟我们的精彩分享。那我们暂时这样。那有一些问题我们没有直接回答的那些，可以另外找，可能通过秘书处找我们，我们会offline 跟你们再讨论，好吗？好，谢谢各位。
好，
谢谢。
有请欧律师留步。我们有请香港律师会副会长余国坚律师为我们代表颁发纪念品。
谢谢。
I cannot wait to introduce the panelists for this section, as we will be hearing from 3 very experienced speakers who will share their insights into the extended role of the general counsels in corporate governance and their experience in how GCs can better communicate and interact with the board. Please join me in welcoming Mr. Jamie Allen, Secretary General, Asian Corporate Governance Association, Ms. Stephanie Chung, Executive Vice President and Chief Legal Officer, Melco Resorts and Entertainment Limited, and Ms. Edith Shi, Executive Director and Company Secretary, CK Hutchison Holdings Limited. Ms. Alison Choi, Senior Legal Counsel, Kerry Holdings Limited, who is also a member of the in-house lawyers committee, will moderate this section. I shall hand over the section to Alison.
Thank you. Thank you very much for the introduction, Joanna. Good afternoon, ladies and gentlemen. I'm Alison Choi. I'm very honored to be the moderator for this panel. We have a very interesting topic today, which is, should GC be given a seat at the boardroom table? This is something which I've always wondered myself, so I'm really excited to hear from our esteemed panelists. We have Edith and Stephanie here with us today, who are very seasoned lawyers leading their respective legal teams in CK Hutchison for Edith and Melco for Stephanie. Both of them have sat and participated in numerous board meetings in different capacities, who will have a wealth of experience to share with us. So I very much look forward to hearing from you both. And we have Jamie, who's a strong advocate and expert in corporate governance, who also has had countless interactions with board directors. So I very much look forward from hearing your insight as well. Before we kickstart, I would like to highlight that a lawyer can in fact take seat at the boardroom table wearing different hats, be it as a legal advisor on an ad hoc basis, or participating as a company secretary, or in fact, joining the board meeting as an actual director. Depending on the hat worn, it would also entail the lawyer playing a different role. This session will take form of a more casual conversational style panel discussions. We will talk about the appetite for including GC at the boardroom, the advantages as well as the disadvantages. We will discuss about how to be a valuable addition at the boardroom table. Last but not least, of course, we would be inviting our panelists to share some practical tips throughout our discussions, and we would end with a Q&A session. So let's start with Edith. Can you please explain the difference in roles for a lawyer or the GC joining the board as a legal advisor, a company secretary, or a director, please?
Thank you, Alison, for the question. I'm very happy to do so. But before I do that, I'd like to just say a couple words of thanks to the Law Society. Can we have the first slide, please? This information has been given to me by the Law Society. Let's look at the reason why we're looking at GC's legal counsel today is because there is a growing number of lawyers that are working in-house. Currently, there is about 13,000 members of the Law Society, 11,000 of whom would be holding practicing certificates. 70% are in private practice and about 30% in-house. Now, when I first started being the general counsel of my company, that was like 30 years ago. We are celebrating our 30th anniversary next year. I don't think there were many legal teams in-house then. But I'm really very pleased to see this information. 30% of the members are practicing in-house. And I really wish to thank the Law Society because I remember complaining to CM a number of years ago that the Law Society doesn't look after in-house lawyers. Thank you. All right, I will answer the question now. The three characters that we were talking about, general counsels would be attending board meetings at the invitation of the board for specific agenda items. This could be to explain a transaction or to delineate documentation that the board needs to consider. They don't attend as a rule, and they are not at liberty to speak unless invited. They don't have any voting rights. Let's look at company secretaries. They are in attendance at board meetings to facilitate proceedings, such as taking minutes or providing guidance in terms of listing rules compliance. The company secretary would be attending the board meeting from beginning to the end, other than specific conflicted items such as considering the company secretary's salaries, or the directors are in private sessions, they want to talk privately. Company secretaries are allowed to speak where appropriate, but they have no voting rights. Directors attend board meetings throughout to deliberate on matters on the agenda. They have the right to speak as well as the right to vote. The general counsel's involvement with board proceedings depends very much on the corporate culture and board sentiments as to risk management and compliance. Is there any value added by the general counsel? And the general counsel's access and status at the board meeting has to be earned. It doesn't happen automatically. I'm very fortunate that my company has a very strong risk management and compliance culture. Without the signing off of the general counsel, no documents get signed. That's all I have to share for now. Stephanie, over to you.
Thank you, Ida, for the interesting statistics and your sharing, which is very well explained. So, Stephanie, I understand that you have actually worn all three hats in different companies in your company group. So what has your experience been like wearing the different hats, and how involved were you depending on the capacity you held when attending the meeting?
Yes, so I think, first of all, the important thing is to understand that each company has its own culture and its own business needs. How lawyers can add value to the board process also depends on how immersed the particular lawyer is with daily management of business and working hand in hand with the management team. For a lawyer or for a team that's been involved with a company's affairs, for example, we find that we get involved in HR, we get involved in transaction execution, financing matters, advising on minority shareholders' right, related party transaction, which means that you really have a chance to add value to the board. So as company secretary for a listed company, I focus a lot on things like technology, introducing latest technology in terms of how do you put together a board book efficiently, which is paperless and environmentally friendly, getting vote in a most efficient way. And that also helped in the board process when everyone walks in with an iPad, other than, like a 6-inch pad that we used to do. And I think that's one way. There are other ways. I think a lot of lawyers are very involved in the ESG movement these days. On the ESA, environmental might be more difficult, but on
就是环境可能有点难，但是可持续性和治理
really within the job scope of some of the lawyers working in-house. And I find that on the governance side, there is certainly a lot of contribution that could be had. Lawyers a lot of time are charged with drafting.
师的责任呢，就是要草。
And with that, we're able to help having key messages being given from the top and really take a lead role in terms of guiding the board in building good governance practices. That's been my experience.
Thank you, Stephanie. I couldn't agree with you more about the importance of role of lawyers playing in corporate governance. On this note, moving on to Jamie. How would you describe the appetite for including a lawyer or the GC in the boardroom in Hong Kong as a director? And how would you describe the readiness to include a lawyer or the GC in the boardroom in other APAC jurisdictions when compared with Hong Kong?
Thanks very much. I think it's quite similar in the rest of Asia as it is in Hong Kong, and that's that there isn't a huge appetite for including the General Counsel in the board. Edith can speak a lot more detail about Hong Kong, and I'm sure she'd agree with that statement. There is an appetite to include accountants, for example, because you are required to have at least one person on your audit committee who has accounting and financial management expertise, but you don't have quite the same rules around lawyers. So clearly a lot of companies are looking for accountants on their boards, particularly as independent directors. You do see companies around Asia bringing lawyers onto boards as independent directors, but they are out from outside the company. So I think there's clearly an appetite there, but not so much getting the in-house general counsel onto the boards.
Thank you. Edith, and what do you think are the underlying reasons for that?
Well, Jamie is absolutely correct. Accountants are needed and not so much lawyers. I have some statistics to share with you. Can I have slide 2, please? This is taken from Board Monitor 2022, compiled by Heidrick & Struggles, is an executive search firm. While this is coming up, I will start. This is about 2021. Last year, there were 66 directors, new directors appointed. And back in 2020, there were only 42. Why was there such an increase? First of all, there is a search for hiring female directors. As we all know, gender diversity is a big topic now. And on top of that, INET's appointment to be beefed up within a period. If you don't do it properly, then companies will be in breach of listing rules. So there was an increase of appointment last year. Let's look at the next slide as to the experience of these appointees. CEO 17%, CFO 14%, COO 5%, Deputy CEO 5%, and other C-level 8%. Other C-level, you don't know what they are. The CLO, Chief Legal Officer, is not there. The general counsel is not there as a separate category, but they might be embedded in one of these. And then let's look at the experience. The next slide, please. These new directors have. 50% is in financial risk and compliance, international business, 14, sustainability, 11, social media and digital, 6, cybersecurity, 5, D&I, 2. I actually had to look up D&I. It's diversity and inclusivity. So, general counsel, where could they sort of slip their way in? They could be the first type, compliance. They could be the second type, having international legal experience. They could be doing sustainability work as well as diversity and inclusivity work. So although they are not on the list as the popular appointees, there is a way for general counsel to find their way in. Let's look at, I don't have any more slides, but I have additional information to provide. I got an intern this summer, and Kathy, thank you very much for doing the work, to go through the 69 HSI Hang Seng Index stock companies as to whether there are any INETs that are general counsel. Now, the finding is, Jamie already alluded to that, there were 10 companies with INETs that are lawyers, but they are not general counsel. They are external lawyers that might be advising corporates. There are 4 companies with directors that do general counsel work, but not at that particular company level. They could be a director from another company, albeit not related. If they're related, they become NEDs and not INEDs. And out of the 69 HSI stock companies, I only found 2 that would fit the bill. Executive director plus, and it's not current GC, it's ex-GC. One of them is myself. Another one is from a PLC company. But you see Stephanie here. There are other non-HSI index companies that would fit the bill. I don't have the opportunity to go through them, but I think that would be a pretty good exercise to run, maybe for your organization. Okay, so we can see that it's not common for, unless we have been able to go through the rest of the listed companies, not common for executive directors to be general counsel of the company at the same time. We can tell that legal is not the focus, it's the accountants that are the treasurer. But there is an increasing focus on general counsel if this general counsel is possibly also a company secretary or a governance professional or a sustainability expert. Jamie would have told us that in the US and Canada, normally the general counsel takes the position of the company secretary as well, but they don't become board directors. So more and more legally qualified persons are getting trained in these other areas, company secretaries, sustainability experts, environmentalists, governance experts. So general counsel can expand their remit. It all depends on what you're prepared to do to make yourself more marketable. Thank you.
Thank you very much for sharing such interesting information and statistics with us. I must say I'm very surprised and a bit disappointed by how uncommon it is for GCs to have a board directorship role. Stephanie, what's your thoughts on this? Do you see that lawyers actually have an edge to be in the boardroom? What are the benefits for having a lawyer as an actual director participating on the board level?
Yeah, I think industry dependent. Certain industries are heavily regulated. in those industry would probably find it very helpful for someone on the board who understand the perimeters within which that they need to operate in a regulated environment. So obviously our company is the casino gaming industry, so we have to navigate those quite closely. I would imagine, I don't know, but mining and a few other industries as well, oil and gas. And then also other situation where if a company has very militant minority shareholders, that's a situation where I think having a lawyer on board would, who can engage in fast thinking during board proceeding, can really help to maintain harmony of board proceeding. Otherwise, the board process can be rather disrupted. But also there are other situations where company structure is a little bit more fluid, where lawyers work very closely with management and operation, and just by sheer exposure to day-to-day management, that particular lawyer have acquired other management skills. So there's kind of a bit of a blurring of line as to whether you're a lawyer or you're part of executive. So there are senior lawyers who sit on executive committee, etc., that participate in daily decision making. So again, someone with that background would be beneficial. But I think echoing, I guess, what both Jamie and Edith have said, statistics tell us that not a lot of lawyers are on board. And I think most people would think that lawyers are way too risk averse, right? And we're taught at law school to analyze situation and be super conservative. So I think if lawyers want to get more involved in board, we just need to change our mindset. We need to really retrain the way we think and we analyze and we look at risk assessment and look at problem solving to be more business-minded.
Yeah. These are very, very good points and food for thoughts for all fellow lawyers here, joining on Zoom as well as physically. And
could I respond to what
yes.
Stephanie is saying? I think the issue of risk averseness is a real one. Our experience in engaging with in-house counsel in different companies, for example, partner organizations or hotels, is, of course, they are trained lawyers, so they take a very legalistic approach to things. And when you're trying to sign a contract or an agreement, quite often they will be very risk averse. They want to, protect their company, of course. So sometimes they will make sort of demands of the other side that are, extremely unreasonable or impractical, or just reflect a lack of understanding of what is the purpose of the sort of the alliance, the collaboration that you're trying to achieve. We had an experience where we were trying to sign an agreement with a partner, and their in-house counsel was putting in clauses that, were absolutely not implementable. And they were claiming ownership over certain things like company data, which wasn't our company data, wasn't their company data, it was public company data, which, they didn't own, the public companies owned it. But they were putting in these clauses that if we hadn't shown a lot of flexibility on our part, the agreement simply wouldn't have gone through. So I think having a really good understanding of, the sort of the business of your company, what they're trying to achieve when they're signing a joint venture or some sort of partnership agreement is really critical. And I think that's one of the reasons why GCs are not on boards, because they do take a sort of too narrow an approach to their work. So.
I think if I get a chance to advise law school in setting the curriculum, is they need to teach lawyer to be real life business person, as opposed just to a really traditional way of looking at issues. Yeah.
And Jamie, would you also think that being a governance expert per se would help to have an edge for lawyers?
Yes, I think it certainly helps, because the whole governance environment, as everyone knows, has changed quite dramatically over the last 10, 20 years. And it's not, doing business today isn't just about deciding what you want to do and working with partners and selling to customers. You're having to deal with pesky minority shareholders, or you're having to do with other stakeholder groups, whether they're environmental or social groups. So there's a wide range of governance issues that you do need to understand. And coming back to the sustainability point, one idea I would throw out there is that, the big issue today is climate change. And if you look at the way climate change is described, it's usually put into physical risks and transition risks. The physical risks we all know are floods, fires, natural catastrophes. The transition risks, a lot of those are policy, regulatory, legal in nature. So if you're an in-house counsel and you have a really good understanding of how transition risks are going to affect your company over the next 5, 10, 15 years, then I think you can be invaluable to your board.
Great, thanks for the tips. Now that we have a good picture of the roles of the roles which a GC can play in the boardroom and the advantages and the disadvantages, what I would like to explore is how to be a valuable addition in the boardroom. After all, as Edith, Stephanie, and Jamie, all of them have rightly pointed out, we as lawyers should be adding value. If we do not add value, people would question whether there's a need or any benefits to give GC a chance to have a board role seat. They may advocate that GC should not be given a seat at the boardroom table. So Edith, what advice would you give to in-house lawyers? Previously, you mentioned about being pragmatic and being a problem solver. Would being a company secretary be a good first step to pave the way into the boardroom and to gain a better understanding of the company culture and allowing of the lawyer to provide more value-added service on top of legal knowledge?
Actually, any additional skill set that a general counsel, a lawyer can acquire will always be useful, whether it's company secretary or a sustainability specialist. I became a company secretary not by choice, because the company secretary left for another job within the group, and the CEO looked at me and said, "You are a lawyer, you can be the company secretary, so that's what you are." So when things happen, I think it's important that one grabs the opportunity to learn. Company secretary is a good step into the board, but I am a little bit, I feel a little bit awkward that a general counsel's job is to try to get onto the board. I think understanding how the board operates, whether it's because you are general counsel and you have that opportunity to go near the board, or you are a company secretary, or you are a sustainability governance expert for the company, it doesn't really matter. I think every step along the way that you are able to build yourself into a better advisor for the company would help. Jamie, I am attending a course on sustainability. It's taking me, I'm only having 3-4 hours sleep every night. So you just have to, it's a continuous life learning experience. And I must say, I understand a lot more. It's very good.
Thank you for sharing with us your personal experience, Edith, which is very thought-provoking and also reminds us all to acquire new knowledge every single day whenever possible. And Stephanie, so can you please share with us some tips to make the first steps to convince the business team or stakeholders in the company to let us go beyond our normal pure legal roles, getting more business exposures, giving more input on different levels?
Yeah, I think the first thing I'll do is learn how to speak the language. I have also gone to business school myself, but I can't really read a financial statement, to be honest. Not like our CFO or our accountant or our CEO. I think I want to read a financial statement better. But I think going to business school is not a bad idea, right? So there are just different disciplines. There's finance, there's marketing. But that gets you into the mindset of the business team, so you're much closer to the way they think. But I think in your daily interaction with the business people, there are a few things that I would observe. Sharpen the risk management skill, and I don't mean analyzing legal issues. Lawyers oftentimes don't look at the legal education as just a tool. Lawyers, if you look at the bag of tools, have a lot of things in there. You know, the legal education is only one of them. And I would say common sense is very underrated. People don't apply it as often as they should. The other thing is, to be honest, just stay on top of current affairs. You know, read The Economist, read the Financial Times, understanding the topics for the day. And apply all of that in building a solution for the business team. A lot of lawyers I observe would throw out issues and just to say, you want to do that, these are the issues, but they don't really help to build a solution. If you identify the issue and be a leader in solving the problem, then you're much closer to the business people. And people then actually want you to be at the table when they have a problem that they want to figure out. And I think the other thing is the very important thing that we mentioned just now is about the mindset. You know, what kind of mindset do you bring to the table? People got to look at the issue differently, not only from a legal point of view. I think that just about sums it up.
These are fantastic advice. Thank you, Stephanie. Now, taking a step back, we should pay more careful thoughts as to what makes a good board director. Jamie, you have had lots of experience dealing with directors on numerous occasions for different purposes. So please let us know what sort of traits do you normally see would make a lawyer a good director?
I thought you were going to ask me a general question about what makes a good director.
Feel free to go on from the general level as well.
I might just talk about independent directors, actually, because clearly executive directors are on the board because they're competent and they're in charge of a certain function or section. But independent directors, you know, we want to see people who aren't just independent, but really have the business experience, have the knowledge of the industry, of the company, to be able to really add value to the discussion. And clearly, if you're coming in from outside, you don't have the level of knowledge that an executive director has. So you really need to do a lot of homework, spend a lot of time, you know, understanding the company, talking to people within the company, not just the other directors, but, you know, the whole range of senior management, visiting the company sites, talking to shareholders, stakeholders. And I think if you're well prepared as an independent director, then, you know, you do have a fighting chance of saying something sensible in the boardroom. The problem, as Edith, I'm sure, would agree, and Stephanie, is that, you know, you do get independent directors who don't spend a lot of time trying to understand the company. They come into boardrooms. They make genuinely sincere comments, but they may not be all that useful to the management of the company. So really trying to understand the management, trying to understand also their constraints, their, you know, their limitations, their resources, is extremely important, I think. And again, it takes a long time, it takes several years, and quite often one of the frustrations, particularly if you have short-term limits on boards of, say, you know, 3 to 6 years, is that, you know, usually after about 5, 6 years, an independent director is just reaching the peak of their understanding, and then they might get moved off the board. But in some markets it's 6 years, in other markets it's more like 9 years now. But, you know, I think really understanding the, you know, the challenges management faces is really essential.
Thank you, Jamie. Now, Edith, being an executive director yourself, what are your thoughts on this? What are the characters that you would personally identify as most effective and useful for being a board director?
Any director, for that matter, first and foremost, must act in the best interests of the company and the stakeholders. There is a lot being discussed about whether GCs are suitable. And whether we should apologize for being just a lawyer, I don't think so. The lawyer is there for the legal aspect of the expertise. Every director is there for a reason. So you can't expect the lawyer to be an IT expert, to be a banker, to be an accountant at the same time. So expertise in the area for which you are elected to the board, we should always preserve that as a director. Good business acumen. You can know all the accounting rules, you can be an IT expert, but you don't know how to apply that to this business. And your comments would sound very hollow. And as a general counsel, to succeed, we have to get very close to the business. If we don't know how our business is run, we have no place being the general counsel to start with, let alone the company secretary or a board director. I would be looking at, as Jamie pointed out, a director that is interested in your company's business. They don't come here just for the board meeting to go through the 1 hour or 2 hours of meetings and then fall asleep in the middle of it. And then from time to time, when they wake up, they ask a question, just to make sure that that is recorded in the minutes, that they have spoken. And very often, these questions are not relevant. I'm glad I don't have these board members on my boards. So a director that is passionate about the business, that is prepared to collaborate, prepared to spend time on understanding what it is what I would look for.
That's very candid sharing and great advice for all. Indeed, as a lawyer, legal experience and knowledge are given, but as we previously mentioned, common sense and also an actual interest and an active participation are all differentiating characteristics. Let's talk about some useful non-legal experience which we may try to acquire during our career in order to be a better participant in the boardroom. Stephanie, looking back, what sort of non-legal experience do you wish you had which would allow you to be more compelling and effective at board level?
Just given the current environment, I wish I had spent some time doing other things. But my current kind of pet area that I'm interested in is actually cybersecurity and cryptocurrency, which we find that more and more we're coming across. And also for any big companies, the threat to your cybersecurity is so great. And that really intersect with risk management and also legal risk as well. And it segue into crisis management, contingency planning, and all of those things that lawyers are very well equipped to do. And just like Edith, I haven't enrolled in a course, but I've downloaded a whole lot of materials and books that I'm trying to read, but haven't got the time.
And Jamie, being the non-lawyer on our panel, what sort of non-legal experience would you suggest our fellow lawyers to watch out and read up in this current climate?
Well, I used to be a journalist here back in the early days. I was at the South China Morning Post and then the Economist Group. And one thing that often struck me about board directors and when we interview companies is how little they knew about the society outside their company, or how little they knew about what people outside their company actually thought of their company. So I think taking an interest in the wider world, sort of understanding more broadly sort of the political environment in which you operate in different countries, understanding the economies of different countries, understanding the societies, learning a language or going to a sustainability course, but just having a broader sort of more macro perspective on the places in which you do business, I think can be invaluable. And it always used to surprise me as a journalist when, large corporations would be surprised by environmental groups, criticizing them, when most people outside the company knew this was about to happen, but often the company seemed extremely surprised when it did happen. Or in my current work now as a governance person, you can see shareholders getting upset with the company and you know that there's going to be a shareholder proposal coming at some point or some other sort of public criticism. And quite often, again, companies are really taken by surprise. So, you know, interacting with as many people outside your company as possible, I think, is really useful.
Great, thank you. Yes, and indeed, it's very important for us all to think and try not to be pigeonholed into being the legal advisor by board members and other business units, and that we are more than that, and we could contribute and participate more than just wearing the legal hat. Now let's think back to our topic, should GCs be given a seat at the boardroom table? And we'd like to invite the audience to contemplate this while we consider some potentially tricky or sensitive situations which a GC may face in the boardroom. I'd like to start with Jamie first. Nowadays, it is common for in-house lawyers to put on their business hat and share the risk of making business decisions. We have previously discussed that sometimes we can't just be holding the business team back, and we cannot just be inhibitors. So, Jamie, how can we balance gatekeeping with appropriate risk-taking, and are there any corporate governance concerns which you would highlight?
Well, I think probably the first thing is to understand the level of risk your company is willing to take, generally and in different areas, so that, you know, as a lawyer, you understand the legal environment, you understand the compliance issues. But, you know, if you also understand your company is willing to take more risk, then I think that, you know, helps you balance your sort of legal advice with sort of, you know, putting on your business hat. In terms of governance issues, I mean, if there are particular, you know, conflicts of interest maybe that your company might be involved in, if it's taking excessive risk, or in fact if it's, you know, potentially doing something illegal, then clearly that's illegal and a governance risk. But yeah, I'll leave it at that.
This is an excellent reminder, thank you. Edith, do you have any on-the-ground examples to share how to hold the fort and perform your gatekeeping role without jeopardizing business decisions?
I recall when I was first the general counsel of the company, that was like 30 years ago. In the middle of the night, I would be receiving on my telephone recording system a managing director within the group calling me up, knowing that I'm not there, and accusing me of killing the deal and having to be responsible for it if he doesn't get his bonus for the year. No, that's my interpretation. So as a general counsel, as the legal person or any legal person within the company, if we cannot tell what is black and white and gray, then we don't have a place to sit within the company. Where it is gray, we should try our best to be businesslike and help our colleagues to resolve the issues. But when it is black, it's black. It has to be black. And whether this is you against your CEO or your chairman, I think as a legal counsel, we serve our purpose by pointing out the issues. I would always put it in black and white, and not so much, you know, to protect myself, because, you know, I can be sacked anytime. So that when the decision is being taken at a higher level, at the board level perhaps, that could be taken into consideration. There are reasons that could be acceptable to the company, risks that the company has calculated and is prepared to take. And it is not the legal counsel to stand in the way. And if that's how a legal counsel acts, then he or she would not be adding value to the company. He should do his job by stating what is correct and what is wrong. And the board takes responsibility collectively. So it's not just one person saying yes or no. The most important is we discharge our responsibilities.
Yes, I couldn't agree with you more, Edith. Thank you for the excellent reminder. Now I have a tricky question for you, Stephanie. Have you ever...
I have to add.
Yes,
Even
yes.
when I was scolded on the phone, the deals got done. And I got what I want.
Glad to hear that. Yeah, going back to the tricky question that was gonna pose to Stephanie, which I have not forgotten. So have you ever come across a situation when there's a conflict or disagreement between yourself and the CEO or whoever you report to? And how do you handle this?
Thank goodness, no.
Edith, have you? Maybe Edith could share later after.
No, but you know, I would have different view with country managers a lot. For example, I would say a lot of time conflict arises out of the fact that people are not able to communicate at the same level. So the important thing is to make sure we are not talking at cross purposes. I will test my own point of view with a spectrum of different people across the organization, just to make sure I haven't got anything wrong. If it is a legal issue, then obviously I will test it with my external counsel. It's a different matter if the CEO said, he wants to do something which is clearly criminal. That's very different. But on most things, since he's my boss, you know, if we want to pursue a course of action which is highly risky, then it's my job to point out what the risks are. And whether he wants to make that decision is in his ballpark. Once I point out the risk, I've done my job. And if he take a very risky move and the company get into trouble, I need to be there to mop up the mess. So it's fine.
Thank you for your interesting sharing. I'm conscious about the time, but before we move to the Q&A session, I've got one last question maybe I could ask Edith. If you had a chance to do your whole career over again, would you choose a different career instead of being a lawyer, such that maybe you have an easier or quicker access to the boardroom in a different capacity?
Well, first of all, it was never my objective to become a lawyer and then to become a board director. But I am a lawyer, I'm a company secretary, I'm a board director. And if I were to do it all over again, I started not being a lawyer. I started to be a music major, and then I did linguistics, and then I did law. I would do it absolutely in the same way. The ability to see things differently, having a different training background, I think helps me a lot in understanding other people, understanding the business, and understanding how I should deal with the rest of the world. I would not exchange it for anything else. I'm happy that after 30 years, I still go to work with a happy heart every day.
Great to hear that. Okay, so now let's turn to our audience. For those joining via Zoom, please feel free to raise any questions via the Q&A function. And for those joining us in person, please feel free to raise your hands. Lady in white.
Hi, I'm Vivian, also a member of the In-House Lawyers Committee. Would you be able to share with us whether in jurisdictions like perhaps UK or the States, the culture of a corporate lawyer wearing a business and a legal hat at the same time in the board, whether it's different to Hong Kong? And I guess the second question is whether do you think this trend will change in Hong Kong in the longer term?
Vivian, you started with the premises that Hong Kong is not the same as the UK and US. That's why you asked whether this would change, correct? Anyhow, I'll try to give you some answer. I am director on a number of UK boards, not so much on US boards. We have very few investments in the US. I think the practice is not different from what we have in Hong Kong. So maybe, and I must emphasize that one size doesn't fit all. I happen to work in a very big company, so there are colleagues that work for smaller companies, smaller geographical coverage. They would have very different experience. But I think at the end of the day, a general counsel, a legal counsel is there to look after legal matters of the company. So whether you are in the UK, in America, in Australia, in Hong Kong, in India, I think our responsibility should be the same. If that helps.
Anything else to add? Okay, we've got a few questions from Zoom. Let's pick one. Okay, the lucky anonymous,
They're all
anonymous attendee. Okay, so is there any conflict of interest for GC and lawyer to be a director of a board at the same time? Say if there's non-compliance. Under duty to the court, does a Hong Kong lawyer have obligations to report that? Maybe Jamie or Stephanie? Jamie on corporate governance, experience sharing, and...
Look, I won't speak to the particular rules in Hong Kong. Maybe Stephanie or Edith can, but you could imagine a situation where if you have a general counsel who's supposed to be sort of overseeing the compliance of the behavior of the directors, if they're also a director, then potentially they may feel less independent in their ability to be, the general counsel. So if that is the case, then yeah, you could imagine there might be situations where you get conflicts of interest, that the lawyer feels too much of the sort of the group, the club, the committee on the board, and doesn't feel the ability to, play their role as general counsel and provide that independent advice. So it's possible, I think.
Well, I think let's differentiate between external lawyer and an in-house GC. As a director, you have fiduciary duty to the board. As senior management, it's the same. So at the board level, you're free to articulate your point of view. So, and the board would discuss and come to a decision. So I see no conflict there. When a firm is an external, when a director is also an external lawyer, I oftentimes find that a bit uncomfortable when I encounter that. An external lawyer comes with a whole sort of other motivation, and then he sits on the board. But having said that, unless he owns share in a different company or in the company that conflict with his duty, and there's a deal that is cross-dealing with him, again, his duty on the board is just like the other director. So, having regard for the professional integrity of lawyers generally is not perceived to be a problem. And certainly in the case of a GC, that's no conflict.
I totally agree with that. Everybody is a professional, so you just have to discharge your duties properly. It doesn't matter whether you are a GC sitting on the board or you are not on the board.
Thank you very much, all. On behalf of the Law Society, I would like to express our gratitude to all of our panelists once again. It was a very lively and engaging discussion, and I personally find it very inspiring and motivating. So thank you, Jamie, Edith, and Stephanie. So should GC be given a seat at the boardroom table? I'm sure each of us have our own stance. But what we hope to have given you, each and every one of you, is some food for thought and maybe some things to work on. Thanks to our audience for your attendance, be it online or physically in person. We hope that you have benefited from our discussions and continue to enjoy the sessions later this afternoon. Thank you. Good afternoon.
Thank you again. May I invite our Vice President, Mr. Roden Tong, to present our souvenirs on behalf of the In-House Lawyer Committee. Thank you. We will now take a short break before we move on. Please, then our next session will start in 10 minutes. Please stay tuned. Welcome back. We've now come to the last section of the conference. Technological advancements, changing expectations of an in-house counsel, shifts in career paths, these have all changed the ecosystem of a corporate legal department. Let's hear from our speakers, Ms. Valda Chan, Group General Counsel, Emperor Group, and Mr. Michael Ting, Chief Legal and Compliance Officer, Hong Kong and Macau, Manulife International Limited, sharing with us how in-house lawyers manage a team of legal professionals, attract and retain talent, and get the department's priorities straight in an ever-changing era. The original moderator of this section was Karen Wong. She could not make it today due to unexpected circumstances. So we invited Ms. Joyce Chang, Senior Corporate Lawyer, Australia and New Zealand Banking Group Limited, and member of the In-House Lawyers Committee, to moderate this section for us. Please, Joyce, the stage is yours.
Thank you. Good afternoon, ladies and gentlemen. Welcome back. Here we come to the final session of today's conference, working with your own team of lawyers. I think this is going to be an appropriate wrap-up for today's conference. I'm Joyce Chang. I'm the moderator of this session. I'm very happy and honored to have this opportunity, even though with a short notice, because I know this session is going to be fun. This session will be divided into 3 parts: individual presentations by each of our speakers, and then followed by a facilitated panel discussion. And then we hope to open up, perhaps say, the last 5 minutes for Q&A session from the audience physically attended in Justice Place today, and also from our online participants. As I said, as a wrap-up for today's conference, throughout today's conference, we've been talking about legal's role as the corporate connector in different aspects. We talked about, in the morning session, about privacy, HR, and then in the afternoon session, about cross-border legal collaboration, whether GC should be given a role in the board. And then it gives us to think whether there is any difference in the expectation of the in-house legal team from the business perspective. In the past, traditionally, legal department function is being seen as supporting function, a backup function, a back office function. But then is this changing now? So, and does it change how the in-house legal team should be managed? And here we are, we have 2 very esteemed speakers with us today. Ms. Valda Chan, Group General Counsel of Emperor Group. Emperor Group has a number of listed companies and, of course, a very wide range of businesses, including the very juicy entertainment business, which personally I hope Valda can share a bit more with us. Valda, welcome and thank you. And then let me introduce Michael as well. Michael Ting, Chief Legal and Compliance Officer, Hong Kong and Macau of Manulife. So Manulife is the insurance and financial services provider, which is a relatively highly regulated industry in Hong Kong. So I think Michael will also share with us later on. So without further ado, let's get started. Please welcome our first speaker, Ms. Valda Chan.
Thank you, Joyce, and thank you to Law Society for inviting me to speak on the topic today, working with your own team of lawyers. For my part, I will first give a brief introduction on the legal departments of Emperor Group, how we set the approach and direction of the departments, and the way how we work with our own team of lawyers. And in particular, I will share with you how we can understand the communication barriers and understand the modern way of communications. You might have heard about Emperor Group, which is a local-grown conglomerate having 6 listed companies on the main board of Hong Kong, and another 5 business lines. We have businesses in the real estate sector, watch and jewelry, securities, hospitality, corporate finance, movie, theater, entertainment, and also furniture trading, and media and publication. Our legal department covers the legal, compliance, and company secretarial functions of the whole group. And in this slide, you may see some familiar faces and some popular posters that used by our company in recent months. To cope with our workload, we require a team of approximately 52 members, comprising 13 qualified lawyers and 10 chartered company secretaries. We have offices in Hong Kong, Beijing, Guangzhou, and Shenzhen. And in year 2021, we were named as one of the Asia's top in-house team. So the way how we work with the lawyers also depends on the macro climate of your departments. And on this basis, the departments, the approach, we have to see what direction and approach you set your departments going forward, and then decide on how you work with your lawyers. So you do the work mainly in-house, or you outsource it to outside professional law firms. There are in-house teams which, by their company's policies and practice, outsource their legal work, like M&A transactions, contract review, preparing announcements, preparing translation of the announcements, and even company secretarial work to professional law firms. And we at Emperor Group, we tend to do most of this work in-house. So, except for, let's say, litigation work, conveyancing work, and bank financing that we have to instruct outside law firms to help us on. So, on this basis, there will be a big impact on the way how you manage your legal departments. What seniority of your team members you would require. Because we do most of our work in-house. We need senior lawyers as well as junior lawyers to do groundwork and research. And what would be the level of supervision you require? Will there be any autonomy of work, or you prefer to have a close monitoring on your lawyers? So also consider the budget of your legal spend, the work logistic. If you do more work in-house, you will also need to have more template agreements and provide training to your team members. So in this slide, I have set out some general guidelines on how do we work with our team of lawyers. Given that it is more and more common for lawyers to work remotely from home, off-site, or with flexible working hours. So the supervisor may not be always around the subordinates to see how the work is done. And sure, no one likes micromanagement. So as the head of the department, are you going to give autonomy of work to your lawyers for particular matters? And in order to maintain standard, you have to build up a robust template document system, as well as a common filing system. For us at Emperor Group, I view these two systems, the template document system and common filing system, as the backbone of our operation. This is the platform for us to share our knowledge, succession of our knowledge, and also for future reference. And even though you work off-site, you are still able to access to all these important documents because the company has built up a system for you to work off-site. And providing sufficient training is very important in our operation too. We have many different businesses, and actually no one knows all this. And there are lots of new laws coming up all the time, and there are also a lot of specific areas like entertainment law, real estate law, securities law. They are all very different. And as the head of the department, I promote work collaboration and work rotation. And this is also an excellent avenue for staff members to mingle and discuss with each other. And understanding their expectations and the work-life balance is also important. You may do something good for them, but the good things may turn out different if the team members have a different expectations. For instance, promoting a staff is a good thing. But if the staff has a different expectation for salary increment in connection with the promotion, the good thing may turn out to be a bad thing. So I see this managing expectation of lawyers is a difficult task, not so easy to manage. So, and in the way how we manage our lawyers and the legal departments, you also have to understand the communication barriers, breaking down silos, both tangible ones and intangible ones. Are there any systems or procedures that preclude your staff members from communicating? Is it a human issue that they don't want to talk to each other? So, do you have enough bonding exercise, off-site arrangement, after work gatherings to promote communication and collaboration? All these aims are sharing of information and resources, and promote communication and collaboration. Finally, I'd like to talk about understanding the modern way of communication with lawyers, especially the younger ones. As we just explored, these days, there are lots of chances for staff to work off-site or work from home. There are flexible working hours, work from home arrangement, time off arrangement. These, especially in the COVID times, these are generally expected. But whereas the traditional way favors more formality in the workplace, and the younger generation also expects more informal communication language and channels against more business-like languages. And work-wise, they would expect more instant feedback on work results. So if they do something, they would expect the supervisor to tell them how their performance was. Are you happy with the result? And they would not have the patience to wait until the year-end performance appraisal to know whether you are happy with their performance. And lastly, I think this is a very important aspect, the means of communication. What would be the preferred mode of communication with your younger generation? By digital means, email, WhatsApp, text messaging, digital conference, or they prefer face-to-face discussion and phone conversation. A very important aspect is, if you communicate with them via digital means, they can choose the time to reply, so they are not disturbed. But if you keep on calling them, and keep on asking them to have face-to-face discussion. Come to my room. Talk to me now. I want to call you. Where are you? So they would feel very disturbed. And there are cases that people don't like to talk to each other. They prefer to send email, even to the neighbors sitting next to them. Why is it? They just simply don't want to talk. So if a corporate culture still adopts the very traditional ways, you may expect a higher turnover rate for the new generation. So thank you, everyone. This is my short presentation today. And I would like to pass the time to Mako.
Thank you, Valda. I think there are lots of practical tips for current legal team heads and also team heads to be. I think it's very all-rounded and comprehensive. Thank you, Valda. So let's please welcome our next speaker, Mr. Michael Ting.
Hi, folks. I'm trying, to be a little bit also informal. I may not be following the slide of each one. I get used of, maybe I will fly around, so please bear with me. But I'm trying to make sure that, we are talking about the new way of working too, so I hope that it will be a little bit more innovative instead of just following the slide or page to page. Okay, for Manulife Hong Kong, Macau, I don't have to introduce Manulife. Manulife is in the insurance business. We are regulated by the Hong Kong Insurance Authority, and also some of our products and has to get the SFC approval too. And for the legal team here in Hong Kong and Macau, we do have 31 persons, and 8 of them are lawyers. 7 are in the legal team, including myself, and 1 in the compliance team. And in fact, in the compliance team, we also got 2 paralegal, and those are mainly in the distribution compliance area, which I will talk about in the next page. For our legal team, we are trying to be not only working for the company, we are trying to see what we can do for the society. And also, we have been in the past 4 or 5 years getting different awards by the professional bodies. Okay, on the legal team, we do have divided into 4 sections if you want to. However, I have to say, those people may be working mainly on those areas, but we are still having some mixture to work together. So say for the general daily work for the insurance area, we have 2 people working on those. And then on the investment, we have 1 person who are very focused on investment. I should have to say, this is focused on investment. And she has to do other things and then helping the team to work together. And on the regulatories, as we have different things, we have to do the filing and also work with the regulator. So we have 1 lawyer more focused on that. And for any insurance company, you will see that agency is a very important part in most of the insurance company, especially the major ones in Hong Kong. So we have insurance contracts and then also the agency contracts, different kind of the compensation scheme for the agents for different teams. And that's why we also have like 1 or 2 person also focus on that area. On the compliance side, we have AML, corporate compliance, product and health, and then distribution compliance. And distribution compliance will have a more focus on legal because they will have to do a lot of the investigation regarding the intermediaries, allegation for the misconduct, if I may use this word, and trainings, and also for the areas that it will be more focused on the conduct and the intermediate conduct and the training side, So this is the structure of Manulife Hong Kong and Macau. And we do, although we have to say that we have different, teams, or you can call it sub-teams, but basically we still work very closely with each other. I think this is something I will talk about, later on. Okay, how to manage the team? Obviously everybody will think the first thing is the budget, right? Budget is important. And the second thing I want to manage is saying that it's the team structure. That's why I put that on the last page and then talk about the team structure. I think as a general counsel, once you start to work in a company, you got to look into how you want to structure the team. This is quite important. I can share with you that 20-some years ago, I was the first one hired for Massachusetts Mutual in Hong Kong as the general counsel for Hong Kong. So my first mission is how you want to set up the legal department. I think at almost 20-some years ago, most of the work are, you can say, outsourced or subcontracted to an external legal firm. So Hong Kong doesn't really have a lot of the formal kind of the legal department that they want to do things together and want to set up a team to do more legal work in-house. I'm sure I will have to assume you guys are all in-house counsel, so I can say this is, I think you all know that most of the companies want to do the job in-house instead of, doing the job or, outsourcing to the external lawyers nowadays, because the in-house lawyer does have this knowledge to know the company, first of all. You don't have to explain to the external lawyer again how you want to deal with things. You probably know your other departments, head or the colleagues, how they want to work to get the work done. So I think structure, I always stress that is very important. And even I can tell you that 8 years ago when I was first hired at Manulife, my first mission is to restructure the team to ensure it is an efficient team which will be able to help the business. Of course, from our perspective, we have to be abide by the law. So because, I always say this word, if the legal department doesn't have any trouble, that means the company won't have any trouble, right? So if I'm doing or anybody at the legal department are not doing his work correctly, then it is actually jeopardize the company. So there are certain things that we have to make sure that we will comply and we have to abide with the law. However, we still also want to be to provide a business solution, So that's, the team structure is important. And in fact, I already told you guys that the communication and transparency, it all comes with what I just said, So the two things, you have to work with your other teams or other departments in the, within the area. So you have to have the transparency, communication, even though within your team. Because as I said earlier, each team I have mentioned there, they have their focus. But we are still working together to make the things work. So within each department or any teams, I should say the teams within the sub-teams in the legal team or whatever you guys call it, in your own company. I think we have to understand that we don't tell your colleague, hey, I'm only doing AML. So the other things that you will have to go to somebody else. I think you have to work together, have a transparency between the teams and also the communication. And all the things around will come into one thing is the key to success. Key to success is to provide a business and also, compliance solution to the business, right? So this is how a legal department, or even though nowadays they're always with legal and compliance, together, and there are a lot of lawyers are now working in the compliance area too. But no matter where you work or which department you are working to, you just have to work together to make sure the things will come out with a one solution. Okay, how to manage the people? Okay, the first thing is always say this: know your people's talent, and know your people's ambitions. So how you want to know your people's talent or know your people's ambition? One thing I want to say that is the last one on the left-hand side is a know when to hire. Other than when to hire, I think when you are hiring someone, you really want to see that. When I interview people, I always tell the candidate, don't be too formal or you just feel fearful or whatever, because you have to treat the interview as a bilateral communication. Being the candidate, a lot of the times you will feel that how I can please the interviewer so that he will hire me, right? But I always tell the candidate that you have to also ask the right question to make sure that you know what are you going to be doing. Is this something you want to do? And it's not only because of money or title or something else like this, but is this something you really want to do? Is this the job you want to work for the rest of your life or for at least 5 to 10 years, in my view? So this is actually a bilateral interview. I always tell the candidate that if you come on board, you decided to quit after a year or so, imagine that, once you have a new person you hire or whatever, takes them 3 months or so to get use of the company or get use of the department, and then also for you to make sure that you can at least, delegate work, don't have to supervise that much or whatever. And then if you work for another 8 months and then people wants to leave, it is a loss, total, I would say it's a loss for the company and also for the candidate at that time, and of course then brought on as an employee. So, for the hiring and also getting to know, the talent and the ambitions, which is important when you are hiring them, and also manage them after they come on board. On the ambition, I can tell you that we always want to have someone who is a high performer, right? There's no doubt. But other than a high performer, somebody with good ambitions, which is good, but don't forget about the independent contributor. It doesn't seem to be independent contributor. A lot of people will say, oh, no, that's no good, right? Then the independent contributor doesn't have the ambition, but that might not be the case. But someone who wants to be an independent contributor could be sometimes good, because when you have your own structure, when you have your own people you want to manage, you just cannot expect everyone is ambitious. Imagine if you have the whole team is ambitious and want to have a promotion, it's going to be quite headache. So you got to know what is this person's talent, how you can help this person, either move, some of those can be promoted more, some of the other people may want different things. You just have to know what they want and then also to watch for that, And that is what I mean, know the people's need. And then obviously, the good team structure and then training will be another thing. But I think, as I said earlier on, I try to talk things together. So some of the stuff on the slide I already explained. Okay. Obviously, the last question is, you may also want to make sure that, whoever you hire will meet with the company's culture or value. Okay, for Manulife, we have a 6 value: obsess with the customer, do the right thing, think big, get it done together, and own it. And also the last one, there's one more last one. I think it's shared humanity. I should have remembered, but it's just too much for me. Share humanity, I remember. And share your humanity. That was the 6 things we have been putting in the value for that. So just make sure that the people you hire is also willing to be doing what the company's value. This is something that you have to do it together. And especially for think big. Nowadays, being a lawyer is not just provide a legal view. You have to look into your business need, and then also, of course, I have been re-emphasized, of course, we have to abide by the law, but you have to find a solution. Sometimes you may not be able to find a solution, But doesn't mean the end of the world. You have to, the business, you may have to tell him, I can't do A. But if you can change, then it will be B. This is something that you have to teach your lawyers, especially a lot of our lawyers will probably work from the law firm for the first few years and then come on board or something like that. This is the time they have to adapt to what is the company in-house lawyers role, and also this is something that I think they have to change their mindset. I have seen a lot of the lawyers coming from an external law firm. They are good lawyers, I can tell you, but they might not be adapted to the business well. They sometimes, I even have a friend, and also, it would take him some time. He was a senior partner for a local law firm for many years. Then he came into in-house. Of course, he has to be knowing that to change his mindset that he used to be the boss. No one would challenge him. And when he came to the company, I think he was saying to me that everyone challenged him, right? So, you have to change the mindset, and also sometimes it's to think big, because you don't have this leisure to put a whole qualified statement at the beginning of your legal opinion, because all you need is what is the conclusion in the first paragraph, right, when you are working in-house. So that's what I want to share with you. I'm sure that, Wilder and I will share a little bit more, on the other questions at the later time of this session. So unless you guys have any question you want to ask me now, but you can wait at the end. And this is my presentation. Thank you.
Thank you very much, Michael, for very insightful sharing. Both Velda and Michael, they are managing top-performing legal teams, award-winning legal teams in their respective companies. But you can see that they have different managing styles. They structure their teams differently. There's no one-size-fits-all formula here, but then it works. So let's move on to the next panel discussion. Let's let Michael catch his breath from his presentation. So the first question to Velda. What is the difference in expectation for lawyers working in-house and in private practice? Do you think the expectation has changed for in-house lawyers comparing to the time when you move in-house?
Working in-house and private practice actually are two very different professions. Not only from the difference in working environment, but it's the approach taken, how you work at your workplace, and the end result and expectations. For expectations are two ways. From the lawyer's perspective, from the in-house, when they go in-house, they would expect they would have lesser work pressure, no more billable hours, and also a better work-life balance. But the company also have a different set of expectations. First of all, the company would expect a smart lawyer, but not a legally smart lawyer. An in-house lawyer should be able to be responsive, effective, and creative in order to support new business models and products. The in-house lawyers also have to know the business well so that they can engage in meaningful discussion with the business unit. And the more successful in-house lawyers are those who can look beyond legal technicalities and engage or have an impact on the business in a meaningful way. So, and for the past 10 years since I have been an in-house lawyer, I have seen from both sides, the lawyers and the company, they are more and more demanding to each other. From the in-house lawyers' side, they would expect to have a higher remuneration package, more flexibility at work, and more autonomy of doing their work. And the company would expect them to yield good results, at least comparable to other law firm standards. So that's the answer to your questions. Yeah.
Thank you, Valda. And I think there is a common theme from Valda's response and also Michael's earlier presentation is that it's very important for the in-house legal team to fit into the business, be it the business strategy, business culture, business goal of the company, and not just working in your own little corner about what is the legal issues here. You can do that, you can't do that. So I think it's important for legal to look beyond just the legal issues. So I think turning to Michael, working in a Manulife, a large corporate like Manulife, so I'm sure technology is one of the big thing here. So do you think technology has enhanced your workflow or improve the work efficiency in your daily work and the operation of the team?
Yeah, I think right now, if the traditional way of just saving legal costs and also provide a legal solution is just not sufficient. And in order for you to really, having what I always call is a performing team or super performing teams, you have to rely on some technology. And obviously, I think every one of you guys perhaps is doing is, I always remind my team members that once you have done something nowadays, you probably have a calendar reminder to see if there is anything you need to remind the business. This is something that you have to do it yourself, but you just can't rely on it, with the old tradition, maybe marking on the calendar, but now the technology can do a lot better than you. And also certain kind of the software, I'm not going to say which one because I don't want to promote for the software company. I can tell you the one we are using at our company that, even though how I run the meetings, there will be a monthly report to tell us, Michael, how long you have been spending your time after work, communicate with your team members. So this could be something important. You don't want to do too much. They will have a report telling you that how many times, you have scheduled a meeting and what's the percentage of all the meetings are not overrun, because they will be able to, to track you through the virtual meetings. And they do have this kind of the technology also telling you that, even they would tell me that how many hours I send emails are off the office hour. So this is something that, you may be smiling or saying that, well, that means you are trying to tell me you are very, diligent or whatever. I want to say it's not. This will be able to tell me that perhaps, do you really want to do that much work, off the work hours, or because you are sending it to your colleagues? These are some of the stuff which may give you some hints. And also, this will be something that you want to know that you are not doing too much by sending too many emails to your colleagues after Friday night or Saturday or Sunday or whatever. So there are tools out there, to help you to do your job better on this. And also, I think at Manulife, we are also proud that, I don't know how many of the, I'm not saying this, I should say this like this way. We are very proud that we also manage our external lawyers' time and also expenses by using an automated system. So we have one system that we are now using. So for our law firm, there's no more physical bill, there's no more invoices I have to approve. And then at the beginning, all the law firms will be entered into the system as our listed law firms. And then when we start one case or one incident, I should say, with them, then we will open up that in the system. And they will be able to submit bills through the system, interim bills or the final bill. And we would be able to compare if we see the rate they gave us every year, we will have a rate to ask them if they want to increase the price, or obviously they never will say decrease the price, right? and then every year there will be some changes or update, but the system will automate it to look into that and track that when the bill is submitted. If they find the bill is not the same as the rate, it was first entered, or in the system, I should say, then they will have an alert to us. So we are also using this system to track some other reports, and for us, I know you never send to me, you probably send to my boss, is even for the same law firm in different countries, we will be able to track the rate of lawyers, for comparing which country is more expensive or more costly, or how they are going to charge, across the region. So there are also certain kind of the things like this, because this also help us a lot. Imagine, some of your junior lawyer may have to go through all the hassle at the end of the case with the external lawyer to make sure that, all their charges are correct or accurate. But now it is all done, by the, I'm always say this because I'm not a computer expert. I always say I'm actually pretty dumb in computers, but the computer can do all those things for us, Okay, I think that's all I have. Yeah.
Thank you, Michael. I think technology can really help improve efficiency and also help us organize data, help us to manage the team and budget hopefully more efficiently. But it can also get quite creepy sometimes. I remember once when I first got a prompt from an email saying that, oh, you've got an outstanding task to this sender, and that's my boss. And I don't think I've got anything outstanding from him, but this is like a creepy sort of prompt from email system nowadays. Turning to Velda,
Yes.
I think you both actually touch upon this. It's about attracting and retaining talents. So any advice for team leaders to avoid high attrition rate within the legal department?
I think this is a difficult question because these days you just cannot avoid attrition rate. And I think remuneration package remains still one of the top most important factors. Yeah. And getting recognized and be impactful to make them feel they are very important at work is important. And also maybe a flexible working approach, be that working hours or the way how they can manage the work. These are factors that can help them settle in the workplace.
Thank you, Velda. And for Michael, do you have any tips, any secret sauce in effectively managing a team of in-house lawyers? I think you've shared a lot, but any top tips from you? Any difficulties or challenges you've encountered in team management before, particularly during COVID times?
I think I've mentioned some, even from the day of the hiring, how you are looking at, to hire a candidate to become your employee. But one thing I'm quite want to emphasize that once you have your employee, you do have to look into what exactly he or she wants. And also you have to show them that being an employee of the company, then whenever there is a vacancy coming up, you will consider that internally. What I mean by that is, we actually hire people from the compliance area, even though it's not lawyer, but I'm trying to share, with you guys how the philosophy is. Yes, from the business side, from from some other unit who have worked in the AML area, from the operation side, we hire them to be the compliance officer for the a little bit junior, for the AML side, and also for any kind of a vacancy coming up, you should always consider internally first, and that will give your employee some of the assurance that, they are being treated first, because you will have to look into that. And there are many positions that in the past within my team that we have a senior leaving to some competitors or what, then we try to look into whether there is another person down one level can do the job. That is something that I think you should look into too. And as I said, also, you got to have a bigger heart. Somebody left you doesn't mean he or she is bad, right? Doesn't mean they were bad because maybe you were not, they had a better offer at that time. There are some other factors who, attracted that person to go somewhere else and left you guys. A lot of the people will say, wow, the guy left me, 2 years ago, why I should rehire him or her, But have a bigger heart, If he or she is good, why not? He or she might have already gained more knowledge by going to your competitor or going to some other, companies. And when he or she returns, then, it could be a better, asset for the company. So I always say this, have a bigger heart, and then just, because as a GC, what you want to do is, there's no hard feeling in my diary. It's always look for someone that if he or she can help you, can help the company, being an asset to the company. I don't care if he left us two years ago or 6 months ago, he decided he want to come back, or, that's what I want to say. Yeah.
Thank you, Michael. I think your colleagues, your team members, they are very lucky to have you as a boss, having a big heart. And then I think this is very true about consider internally for any promotion or any job progression, because I think in an in-house legal team environment, in many teams, we can see that the structure is quite flat. So having different opportunities will be very desirable for I think, training and also talents development. So thank you. Being mindful about time, I think we still have time for one question, perhaps from the floor here or online. Any questions? And I will check the Q&A session. Thank you. Anyone?
So thank you, Michael. Thank you, Wheeler. Perhaps this is a question that I would like to ask for our members. I always hear from our members saying that it is getting more juniors joining the in-house community. In the old days, they always say that, you should at least obtain perhaps at least 10 years before joining the in-house. But now I'm seeing more and more NQ joining the in-house. Do you see this way? And if so, what is your advice to them, in particular to our young members?
Well, I can confirm I have seen this way. And in fact, I can say that we are the first insurance company who are having trainees and trained at our place, and he became a lawyer. And although I have to tell that he finally left us to the regulators. But I have no doubt and I have no regret to do that. And also, I think sometimes if somebody can really make up his mind to go in-house, why not? I just don't want to see that, some of the lawyers, I don't know, I'm not saying all, young lawyers join in-house because they see the remuneration is better than going out working at the law firm, especially during the first few years. But yes, this is a trend. I can confirm that.
Yeah.
I concur what Michael just said. I have seen this trend too. And even in our Emperor Group, we also do recruit young lawyers, newly qualified lawyers, to support our work. And indeed, junior lawyers, they can do better legal research work, better than the mid-level and senior lawyers. So I really welcome all these newly qualified lawyers to join the in-house profession.
Thank you, Velda. Thank you, Michael. I think this is good news for the different seniority of the legal profession, seeing the increasing population of in-house lawyers. And thank you one more time, Velda and Michael, for your time and for your very interesting sharing with us today. And I'm calling the end of this session. Let's give our speakers a big round of applause. Thank you.
Thank you, Velda, Michael, and Joyce. May we have Vice President Rodentong, Mr. Rodentong, to proceed to the stage to present souvenirs to our panelists. Before we come to an end, may I now invite Chairman of the In-House Lawyer Committee, Mr. Adamus Wong, to deliver his closing remarks for us. Adamus, please.
Well, good afternoon, distinguished guests, ladies and gentlemen, and thank you for attending the conference today. I hope you all enjoyed the conference today. Speaking for myself, I really enjoyed very much and find it, all of the sessions to be informative and useful in my practice as an in-house lawyer. Now, as we drawing the conference to a close, this is the Oscar moment where I get to thank all of the people who all contribute to making the conference a success for today. I think first and foremost, I'd like to thank our MC for today, Joanna Tong. Without her, sort of like making things running smoothly for today, we wouldn't be able to have a very smooth conference today. So thank you, Joanna. We also want to thank staff of the Law Society Secretariat and all members of the in-house lawyers committee of the Law Society. Of course, we want to thank our President, CM Chen, and Vice President Rodentong, who spent the entire day with us today. And of course, we want to thank all of the panelists for making today's conference a great success, particularly our mainland counterparts for presenting at the conference for the very first time, sharing their experience with us on how lawyers from both jurisdictions can better work with each other. I also like to thank the Department of Justice again, echoing what our president said this morning, for providing this prestigious venue and very convenient venue right at the heart of Central for the conference, so it could be held both in person and online. And last but not least, I want to thank the most eminent in-house lawyer in Hong Kong, the Secretary for Justice, Mr. Paul Lam, for giving the keynote speech today, sharing with us how he envisages our in-house community may further contribute to the success of both Hong Kong and the mainland. So thank you again for attending the conference today, and I hope to see you all at the conference next year. Thank you.
Thank you, Adamus. Ladies and gentlemen, we have now come to the end of the conference. Our heartfelt thanks to all panelists for their time and sharing today. We must also thank every one of you who joined us at the conference. Without your support, the event would never have been possible. For participants who joined us in person, please don't forget your personal belongings before you leave. And please continue to stay well, and we hope to see you all again next year. Thank you.